May it please before
Yes.
Lordship. My lord, I beg to mention item number 13 of this today's list, my lord.
Item number
13, part third, my lord. My lord, matter may be adjourned for the day and may be fixed day after tomorrow, my lord. I am for the Seva, my lord.
where is Mr. Datta?
I am on.
Before vacation, this bench is not available singly.
Then my lord, the date may be fixed after vacation.
We'll release it from part third. We'll see what will happen. Okay. A prayer on behalf of Mr. T.C. Sutia, Learned Standing Council for Seva for adjournment is made. Prayer is allowed. Full stop. However, prayer is allowed. Accordingly, matter stands adjourned and be listed on.
Any day, my lord, after
Give a
vacation.
date.
My lord,
Any
on
date will give
18
after Puja
18
vacation.
18th of
Huh?
18th of July, my lord.
18th of July 2024. Full stop. The matter shall not be treated as part third anymore.
My lord, let it be remain part of my lord.
No. That's not possible. Let us see what happened after vacation. We'll see. Yes, next.
My lord, even my lord, without fixing the date, my lord.
No. It's not possible. It's not permissible. Yes, next case.
Lordship, in item number 35, the counsel for the petitioner is unavailable today, Lordship. Okay, matter may be adjourned for the day and may be listed after the vacation, Lordship.
Item 35.
30, the content is,
Which council?
Lordship, Mr. S. Datta.
For-
For the petitioner.
For the petitioner. Okay, on the prayer of the learned council for the. There is no name of. Okay, for learned council for the petitioner, matter stands adjourned and be listed after a week.
Lordship, another prayer is,
Listed after vacation.
Lordship, there's a writ petition has also be filed by the petitioner. Matter may be tagged with the.
No, without the writ petition, we cannot pass that order.
Obliged.
If you want an adjournment, it is adjourned. That's all. Yes.
Sir, document item 19. I'm praying for 1 week time to file IA.
Item 19. What kind of IA?
So implement corresponding number 8.
Implement. Okay, you are for a petitioner. Huh?
Yes.
Learned counsel for the petitioner seeks for an adjournment for a week to enable him to file an IA for implement. Full stop. Prayer is allowed. List after vacation. After summer vacation.
May
Yes.
yes. Please, your lordship. Lordship, I beg to mention item number 39, lordship.
39.
Yes, lordship.
Yes.
In this case, I would like to file implement petition, lordship.
Okay, same order. Petitioner.
Yes, lordship.
Same order. The learned counsel for the petitioner seeks for an adjournment to file an implement petition. Prayer is allowed. List after summer vacation. And I go to negative. Yes,
Please, lordship. May I beg to item number 26, adjourned for the day
26. Yes,
26.
you are for.
The petitioner on behalf of MK Sudris
Yes, what do you want?
after vacation.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation.
Highly.
May I please, Lordship? I beg to mention item number 50 for supplementary list.
50.
Item number 50 for supplementary list. 50.
1.
50.
No. We'll pass an order a little bit later, okay? Because there is some defect. This is by mistake, this has been listed.
Yes,
Okay.
May I please, Lordship, I beg to mention item number 55, the supplementary list, my lord. Sir, perhaps we'll remember has heard this matter, my lord. We have also submitted.
We'll yes, tell us.
As your lordship, please, yes, your
We'll-
lordship,
We'll pass the order today, details order, because you have already,
Yes,
given written note. We have dictated somehow it was, I do not know why it was not listed.
Yes.
We will now reserve or pronounce the operative part. You will get the order by the next week.
My lord. I'm deeply obliged.
Yes. Because hearing is concluded here.
Yes, my lord.
Yes.
Yes.
Okay, let's let this that hearing concluded, judgment reserved. Yes.
Lordship, I beg to mention item number 33. The respondent has filed an affidavit. So Lordship, some time may be given to file the
Item number
33, Lordship.
learned counsel for the petitioner prays for and is granted 3 weeks time to file rejoinder affidavit.
After vacation.
Full stop. List this matter after vacation. Yes, Mr. Talukdar.
Yes.
My lord, in fact, before coming to the instruction, my lord, in respect of item 1,
Hmm.
my lord, I want to, my lord, submit one thing
Hmm.
that,
Item 1, we have not issued even notice.
No, my
We
lord,
not-
in
we
fact,
issue
what
a
has-
notice with
yes,
notice.
that is correct, because
Ah.
this is the lead matter
Hmm.
and my lord, other matters are following, my lord, item 1.
Hmm.
And since no order has been passed, my lord, in this matter, so it does not reflect
Hmm.
that this is a part heard matter.
Hmm.
And in fact, these matters were, my lord, fixed on 8.
Hmm.
On 8, my lord, the matters will listed before another coordinate bench.
Hmm.
So I have to submit, my lord, that this is a part heard matter
Hmm.
before your lordship, my lord. So this is how today,
Hmm.
my lord, these matters are before your lordship.
Hmm.
And the instruction which I have, my lord, with me, it pertains to, my lord, 4-6 relating to that date, my lord,
Hmm.
8-6.
What was
So
that?
latest instruction I don't have. It says, my lord, further time is necessary.
Okay.
What I am
Okay,
proposing, my
we'll go to that. Let us first take up this
Yes.
matter.
my lord. Lordship may issue notice on that, and my further request, my lord, that most of the orders are being passed in item 6, 404. So let that case be the lead case in this series, my lord.
Okay.
That would be convenient for the registry also, my lord.
Third MSB Bhuya, learned senior counsel, assisted by M. Chakraborty, learned counsel. The present application is filed. Present application is filed
Oh,
seeking a writ of mandamus against the respondent authorities for arrear of salaries as well as retirement benefit of the petitioner. Full stop. Issue notice returnable forthwith. Mr. Talukdar accepts notice on behalf of
My lord, on behalf of
all the respondents.
2, my lord, no 2, no 3, 4, 3, 4, my lord, 3 and 4 only, my lord.
3 and 4. Who for one?
Government of
Uh,
One, my
Assam.
lord, is the chief secretary, my lord, and 2
Yes,
is the finance.
any government advocate? D not, Mr.
no.
D not accepts notice on behalf of senior government advocate accepts notice on behalf of respondent number 1. Mr. Borpujari for 2,
2, my lord.
3 for
3 and 4, my lord, I am representing.
Talukdar for 3 and 4.
Provident
Notice
fund.
to respondent number 5 to whom? Any standing counsel for Provident Fund Commissioner?
Provision for-
Mr. Day was there earlier, is not.
6, 7, 8,
Okay.
8,
Some cooperative, then respondent number 6. Talukdar, you are for 6?
my lord, 6, 7 and 8, my learned friend appears normally.
Notice may go, Lord. I am not standing down.
Okay. Notice, not forthwith, returnable on give a date.
All the matters will come together, my lord.
That's why.
After vacation, my lord.
Give a date. No, after we want to close this and on next date we'll otherwise we'll proceed on individual
Yes, correct.
contempt and all.
Lordship will record this, man.
Ah.
Last chance, man.
Ah.
I have also conveyed the message.
Ah.
Because the honorable court will not grant time again and again.
You do it on your own or otherwise we'll proceed in the
Correct,
contempt.
correct,
That's
sir. I also agree, my lord. Lordship will, last chance, my lord.
No, let them have a.
29 হলে নহব আজি কিমান তাৰিখ
As you said, 25th,
18th,
18th of July.
18th of July.
21 will lead to my lord release from the part. So before that, my lord.
18th of July.
18th will be Thursday, my lord, hearing day.
Okay. 18th is not possible.
25 করবি
25
আজি কিমান?
বেলেগ আছে বহুত।
No, I am giving 21st.
23rd
23rd.
23rd.
হ'ব
Okay. Just a minute. July, na?
মই নকৰো
Okay. July 20.
Third, my lord.
23rd. You say 29th. Somebody said 29th.
29, no, my lord.
No, 29th will exceed the.
Exit, that is why, my lord. আজি
So it will be your 29th or 25th. Tell us. Not
25th.
25th.
23rd করলে হবে নাকি
23rd.
23rd
23rd is Tuesday, my lord, can be.
can be
Okay. Returnable on 23rd of July 2024. Full stop. The petitioner to take steps for issuance of notice upon respondent number 5 to 8 through registered post with AD. Petitioner is also permitted to take dusty. Dusty
Optional, my
if so advised.
my
If so advised. However, in the event dusty service is taken, can be routed through the registry of dispute. That is optional. Okay. This is an order in item number
one.
1. Then, which is the item, Mr. Talukdar, you want to?
Item 6, 404/2020.
Item 6, give the item number 6.
6, 7, 8.
This, my lord, may be the lead matter because most of the orders are passed here, my lord.
As far as item 5 is concerned, I have a small prayer.
Yes.
Of course, Lordship has just said that if they do not do anything by the next day, Lordship will continue with the contempt. But my small prayer is that let the contempt be detect, because here totally different jurisdiction. There, I don't know what the prayers are. That is totally on a different footing. Whatever follows from there will be applicable to us as well. So, but then let the contempt petitions be detect. This is, and contempt petitions are already fixed for hearing by Justice Soumitra Soikia. That order is also there.
Where is, give that order?
Lordship, this order, Lordship can see, this is 22nd of February, 23.
Can I pray one?
Let the contempt go, we'll see the.
No, it's a genuine prayer, my lord. I'm
Huh?
not opposing to that.
Huh?
What I'm trying to say, since, my lord, I am also agreeable, my lord, with the petitioners and your lordships, my lord, that this is the last time. So for the last time, your lordship may, my lord, retain these matters together. On the next date, if nothing happens, then your lordship will proceed. Lordship will make it clear. For last 3-4 times, my lord, they have accommodated. Because if something happens, then, my lord, everything.
Full stop. Item number 6. 6. No, 6. Lead case item number 6. Give the item number 6. Full stop.
6 is that writ.
Item number 4 also contempt matter.
No. Dealing with
এটো আপনি লিখিব WPC 404/2020, WPC 1086/2020 and WPC 3189/2020. Full stop.
Oh, for contempt.
These 3 repetitions are filed by the petitioners who are / with employees of Escart Bank, a bank constituted under Assam Cooperative Land Mortgage Bench 1966, with a grievance that their salary / pensionary benefits have been withheld. Full stop. Okay. Then apni order to 5.1 or order to sabo second paragraph, third paragraph, fourth, fifth. In the aforesaid backdrop, this court, in the aforesaid backdrop, this court directed to list this matter on 15/2/2024. After hearing at some length, this matter was directed to be listed on 15/2/2024 as part heard. Subsequently, on the prayer of the learned counsel for the respondents, matter was adjourned on 15/2/2024 and the respondents were granted time to apprise as regards non-implementation of this court's earlier orders, as well as of the Honorable Apex Court as regards payment of dues to the ex-employees of the Escart Bank, and certain orders directing restatement of the petitioners in service. Full stop. However, matter has thereafter, on 27/2/2024, it was submitted that government in the highest level in the co-person department has taken a call in the matter and proposes finally to resolve the impasses existing in the bank by taking concrete decision without further delay. And a proposal was also submitted before the finance department for revival of the bank. In the aforesaid backdrop, the matter was again directed to be listed, and an order was also passed to list the connected contempt methods arising out of different orders of payment of salary / pensionary benefit so far relating to the escort banks. Full stop. The learned counsel for the petitioners representing the representing the petitioner is a contempt petition has made a prayer that the contempt petitions be detached from these three writ petitions. Full stop. This court is also of the view that contempt should take its own course. Accordingly, the contempt petition shall be detached from this present three writ petitions, and the contempt petitions shall not be kept as part heard and be listed before the appropriate bench as per roster. Full stop.
Statement as well.
That we have said. Okay. Pensionary benefit, wages, and reinstatement. So contempts are released.
Therefore, the contempt matters all may come up together, Lordship.
Contempt matters
No,
may
all
come together.
contempts are I have released from part heard.
Lordship, part heard, it's okay,
Part
Lordship.
heard, it's okay, but
No, that is, these are
come up-
detached and be listed,
Lordship,
listed.
along with two other cases, I am giving the numbers, Lordship. Contempt matters.
No, you make a mention because this order, we have this is detect it. You make a mention, then there are other contempts. Okay, now coming to the present three writ petitions, Mr. S.K. Talukdar, Learned Counsel submits on instruction, submits that that the matter regarding liquidation, sales, revival of escort bank is under consideration of the government, and therefore and accordingly the competent authority has requested him to take an adjournment in this regard so that the decision can be intimated to the court on the next date by the next date fixed. Full stop. As the government is considering the matter of liquidation / revival of the escort bank, inasmuch as the present writ petition also involves claim of the petitioners as regards pensionary benefits / reinstatement / arrears of salary. Therefore, there will be a bearing upon the matter once upon the matter in the event any concrete decision is taken as regards liquidation or revival of the bank. Full stop. Accordingly, matter stands adjourned. However, it is made clear that if no such concrete proposal or however, it is made clear that if no such further instruction is received on the next date fixed, this court will proceed to decide the matter on its own merit. Full stop.
one more prayer, Lordship, since all the matters were part heard. So Lordship will keep that, our contempt also as part heard and
No,
let
no,
it
no.
come up separately.
Contradictory statement. He has made clear.
But
No.
Yes.
In the contempt of report, it is also submitted that the similar contempt matters are fixed for hearing, after 2 weeks. This is 2 weeks after February. No, let us not. Okay, list accordingly.
My lord,
So contempt matters are gone from this scope of this court, and then writ petition, these three writ petitions. Agor kestot likhibo Bornali B. Bhuya, senior advocate. List this matter along with WPC 18.
my lord, this letter 4/6 may be made part of the records.
Okay. The communication dated 4/6, where is that? Communication dated 4/6/2024, on the basis of which Mr. S.K. Talukdar has made submission is made as part of the record and marked as X.
Obliged.
why make this prayer? Because the proceedings were taking long. And so these people are really, they're in a verge of-
Therefore, you proceed in the contempt. What will you get in the contempt?
everything was part.
Yes.
So,
Next case.
obliged.
I'm obliged.
17 days.
Where is the scan copies?
49 maybe up to because arising out of the same. What's it, 2 days fixed for cross-examination, one witnesses come, he is going to be examined for the trial court.
Go and cross-examine.
My lord, already my person are there. My colleague is there, my lord.
Item 49.
17 and 14,
Mosumi. He's saying this is item number
17.
17 and 49 together.
No, 49.
49.
One will be same. So,
This is out of same.
same case.
On that 49 and 50.
No, that was a mistake. Therefore, a subsequent list is
Your lordship knows the facts, my lord, so today I'll not, I don't wish to make any submission, your lordship. Because already I have argued this twice.
you are similarly with the others. And what is your case, Mr. Ahmed?
About 3 years already.
You are the main person from whom the truck. And they are the person who, according to them, assisted and
Yes.
delivered. Mr. Kal,
Look,
subject to you are going to upstairs, I think he is entitled for parity.
no,
Exactly same.
I have some submission, lordship, after considering my submission, lordship.
Definitely, there is no doubt about. Ahmed will be a different, he is in a different footing. But so far, Mr. Vishwas is concerned,
I have some submission to make, lordship.
yes,
Lordship, page,
just tell us, see, we have rightly, wrongly passed an order,
lordship,
is not it? Now tell us what is the distinguishing factor between the order passed earlier and him,
lordship,
if any.
my submission will be.
Let us be clear.
There cannot be any parity. in
No,
case
no,
of
there cannot be any parity.
Yes.
We are not saying parity in a situation. The materials available against the person whom we have granted bail
Yes, that is there, lordship, I'm not.
and against him, is there any distinguishing factor
Lordship may come to page 32.
of
Role of the bail application of the item number 17.
item, that is Bikram Dev Barma,
Become the
item
17.
17,
Page 32,
page 32.
paragraph Roman 4. He is described as a co-supplier.
Okay, page 30,
32.
32. Described as a co-supplier. Okay, and what is his status? The earlier one? What is his name? Vishal.
Saisan Dev Burman, that is just below that, Vishal, Saisan. Then-
Saisan is co-supplier, that has been already granted bail.
Vishal granted bail. Then another buyer Dev Burman granted bail.
Married lordship.
Yes.
Vikram Burma was co-supplier of ganja.
Hmm.
He was present at loading time of the ganja in the truck seized from Mohanpur jungle area in presence of two accused, Muzamil Hussain and after obtaining load seized vehicles, further escorted him to Guwahati along with other co-accused in follow-up action. He was close contact with Vikram Dev Burma. Yes.
Now let us see what is your materials which on the basis of which you are relying on.
This is the materials, lordship.
No, this is the statement. What are the evidences against them? You propose evidences.
Lordship propose evidence, lordship, then we have to go to the deposition recorded by the learned trial court. Copy that is available before your lordship in the LCR.
Scan copies, na?
Yes.
Now tell me, what is the additional submission, Mr. Kal, so far regarding this? Your
Lordship,
argument.
we have filed our objection also. Lordship may come to one judgment we have annexed there, that is Ajay Kumar Singh.
Ajay Kumar Singh.
Lordship, paragraph 11. Internal page 35.
Paragraph 11.
Married lordship.
Yes, you read it.
Small paragraph.
Hmm.
The information revealed by two accused persons indicating that both of them knew the respondent accused when they had connived with him to transport the illicit ganja, and they were in direct contact with the respondent accused all through of his mobile. The facts are unfolded from the complaint FIR and the statement of the FOP2 accused person recorded under section 67 of the NDPS revealed that the respondent accused is kingpin of the organizer of the illicit trader in ganja.
Okay, so according to you, this is the exactly similar case.
Yes.
They are in contact as per your.
In this
What
case,
is the page paragraph?
paragraph 11,
Paragraph page.
page 35, internal page 35.
Internet page 35 of your affidavit.
My objection.
Okay. So we'll go through the scan copies, we'll pass an order.
Lordship, with regard to item number 49.
Ah.
Lordship,
70, just one line, my lord. My lord has, the counsel for the NCB have read para 11. My lord will also read para 12.
Para 12. Okay.
My lord will read para 12. And para 12 is sufficient indication of why this bail was rejected.
Okay,
Lordship, item 49, page 37.
this is disposed of. We'll pass the order, which way we do not know, but we'll go through the record. What scan copies are there since earlier occasion scan copies are not there. Yes, Mr. Ahmed.
Lordship, another fact, one witness has come, is examined today.
Okay, okay, that will record. Now tell us how many witnesses total?
Four.
4. Total
Total 9.
Total 9. Total 9 examined.
4.
Examine 4.
Cross of PW4 is going on. Lord.
Cross of PW4 is going on. Okay. At that stage, how many witnesses were there?
Say, my lord, four witnesses. What had happened with the fourth witness is this.
This is second cross examination.
Fourth witnesses, there are five accused person.
Huh.
For all other accused person, cross-examination was done regarding the fourth witness. Save and accept, probably my friend's client, my lord, his cross-examination was pending because of some reasons, my lord. His cross-examination is probably
Going on.
is going on, or I'm just within 1 minute during the course of
Lordship, the
submission.
fact was that no counsel was there, legal counsel was appointed, it didn't appear. This is the fact.
Okay, now who is cross-examining?
Probably some
legal aid counsel.
legal counsel.
Okay.
And Lordship, interestingly,
Cross-examination will start at 1 o'clock.
Lordship, interestingly, in trial court, they have no counsel, but in high court, for bail, they have means to engage counsel to prepare bail, Lordship. This is also to be noted by Lordship. This is very important aspect.
Submission, Lordship, I have strong objection to that, Lordship, because if they are making that kind of submission, that it will be difficult for us to appear, because we are engaged only for bail purpose.
No, I'm
We
not
do not
engaging my
try
land
also
friend.
try
He's not alleging.
We cannot suggest-
He's
we cannot
stating a
suggest.
fact.
I'm the fact of the petitioner.
He's also surprised why. She's not blaming him. Take it in that way, sportsmanship. Why are you taking it? He said that why it is surprise. Here is a bail, but there is no.
Because trial takes 4 years, difficult to maintain an advocate for 4 years.
Yes, my learned friend has. acted
Yes,
on it.
he's correct. He lost faith on the judicial system. Anyway, yes, what is your Mr.
Page 37, Lordship, paragraph 6.
No, let him
No,
hear him
Lordship.
first.
My case is that, Lordship, he is in custody for about 3 years. And till that, Lordship, only 4 witnesses examined. And
Sir, who are these witnesses examined?
Mostly official witnesses.
How many, who are these witnesses? Just tell us how,
page 51, your Lordship, you will find.
Lordship, page 51. One is,
page 51 of
petition.
Of
Lordship, Rakesh
Ahmed's
Shukla,
petition.
he was a journal director. Now he has been transferred to some other place.
Then how many total, who are this? With PW1, who is PW1?
He was a journal director at the relevant time at Guwahati.
Zonal director. Then PW2,
I mean, he was
who is he?
a FSL expert.
FSL. Then PW3,
Mrs. Srimati Tulika Moran. She is on maternity leave for last more than 1 year.
who is she?
He is a superintendent in NCP.
She has been not examined.
Series will not probably, they will not examine.
Examined. PW3, what is her
No,
status?
that's what-
Officer?
He is superintendent NCP. Lordship, I am doubt whether she has been examined.
Superintendent and CB. No, if it is marked as PW3, then she has been examined.
Yeah, sir, he is submitting from page 51 that the name of the witnesses are there. Whether he is examined or not, in that respect, he is submitting. Probably he is correct.
Not examined.
Probably not, because she is on leave, as per my information.
Not examined. Then who is PW4?
4 is Pankaj Chauhan, is a IO. He is appeared, his,
IO examined?
yes, he is, today he is crossing.
Okay, examining. Now, who is PW5? What about the possession?
Possession
Who
regarding
is, and who are the other witnesses?
Lordship,
the
5
independent witnesses. are
is
there.
also IO, he was transferred.
5 is IO transferred, not yet examined.
6 has been examined,
PW6 examined.
7 examined. Then rest 2 are independent witnesses.
No, then who are examined?
He is submitting the total witnesses.
No, we understand.
Lordship,
Now let us understand how many witnesses are examined. We know 9. Who are those out of 9? Who are those examined?
Anuranjan,
DJ Hazarika.
One
Then
is the
Pankaj-
FSL
Okay, that is says that FSL.
and the other is the zonal director who gives the authorization.
Hmm.
And one person from the raiding team. One person from the raiding team and one probably.
IO.
No, IO, my lord, last witness.
No, this is he's saying that
No, IO
IO.
cannot be. IO
That is why.
IO otherwise also in a criminal trial, the last witness would be.
Because he'll have to sum up
Yes,
everything.
absolutely. 145 contradiction. will
Yes,
have to be
everything will come.
there. Yes. So that fourth one would also be in all probability a member of the raiding team.
Pankaj Kumar.
Pankaj was a member of the raiding team.
Yes, he
Intelligence
appeared today,
officer.
his examination will be done.
Okay.
today.
These are the only witnesses.
And
Will enter the count.
And who are the others independent
2
witnesses?
independent witnesses.
Independent witnesses, then the IO, then my lord, would be the seizing officer.
Seizing officer is being examined today, Lords.
Okay, he's seizing officer. No?
Yes.
Member of the raiding team, seizing officer saying.
Now 1, 2, 3, 4, 5, 6. Two independent witnesses, 4, 5, 6. Who are the 3? One is IO.
And another.
7. Who are 2? Other 2.
Tulika Moran, probably Tulika Moran, she will not be examined. Lord.
Who is?
Tulika Moran,
And
What is her role? Tulika Moran.
probably she is,
Superintendent and chief.
Superintendent, they
issue authorization.
issue authorization for the raiding team. They
But
constitute-
it also authorization, na?
Yeah, they constitute the raiding team and they authorize the raiding
But
team.
whatever zonal director is also authorizing.
My lord, because there are separate mandates under the act, the
Different
immediate
roles.
information has to be escalated to the zonal director.
Zonal, okay. So 1, 2, 3, 4, 5, 6. Then IO 7, 8. Who is the other?
2 independent.
Two
witnesses.
independent.
2 independent. Till now 4 examined. 2 independent. 6. 1 is IO. 7. 1 is that superintendent. 8. Who is the other?
Also invariably forensic.
Forensic.
No, forensic is.
Forensic we have already examined.
Then journal director,
The
superintendent.
other
2.
would invariably be a raiding team member. They come, they examine 3, 4 raiding team, seizing, IO, independent.
Okay, yes, Ahmed. What is your case?
My case
Only
is a
delay.
Delay.
Only
And
delay.
plus. And those, your lordship judgment is also there and all over, so even if possession is there, that 21 will be still in force, lordship. They're about 3 years in custody.
That is where our difficulty lies with this court. Mr. Biswas is aware. He has expressed his view on that day.
That I understand. Had it been a case of 1 year, 2 year, I would not have pressed much, but it is about 3 years.
But here
Only few
50% exam, how would, yes, what is your proposal from the prosecution side to produce the witnesses?
Lordship, on the date fix.
3 months?
But Lordship, another difficulty before this honorable court, as per the latest judgment, probably court will
Allahabad
be
High
difficult
Court
to,
bar assistant.
court will be difficult to fix at time.
No, we are not fixing. We can request.
No, that can be.
We are requesting only.
309.
And we are expressing our desire and expectation.
Lordship, from 1st of July, the new law come into force, probably there will be no delay because some procedure for examining the witnesses through online is also
That
provided.
is there.
probably thereafter
In
there will
NIA
be.
court, they are doing this. In NIA court, NIA court, witnesses are being examined from Himachal, from Rajasthan, they are doing.
But difficulty before this lordship, additional session judge lordship, we are making request, but said that there is no system will be updated, then they will allow. And because from 1st of July, lordship, this system is to be.
Yes, it should be enforced.
Yes, lordship. And probably thereafter there will be no difficulty in, there will be no delay in trial also.
Okay,
Just I'm handing over to.
what was the total quantity?
500.
What about the other accused which we have granted bail? Are they participating? They are participating? Where any statement made in our bail application regarding them?
Because I can tell from my experience, because I am the also engaged in the trial court also for to defend them.
Okay. Okay, we'll pass this order, but don't expect by.
Or may I pray one thing, Lordship, this matter, this my case, Lordship, that after vacation, your Lordship may fix, because if any progress is there, that can be seen.
That is a better proposition. Every warden is lesson, isn't it? Education like, huh? What is your item number? Item number
49.
49.
49. Mr. Ahmed, learned counsel for the petitioner, submits that matter may be adjourned and be listed after vacation.
And with up-to-date record.
After vacation, full stop. Vacation, full stop. Prayer is allowed, full stop. Registry may obtain. But what is problem is that by virtue of Supreme Court judgment, this way, this or that way, the road ends in a blocked wall. Is not it? That is also there. Anyway, let's this matter. In the meantime, we are not giving the registry, you just obtain the instruction.
I'll obtain them that.
In the meantime, the parties may obtain the up-to-date status of the trial. Stop. List this matter on. After vacation, give a date.
On 18th or 19th.
19th.
Lordship, 23rd will be probably there.
23rd will be. Okay. Mr. Trial, just Kyle, you just try to finish it up.
No, Lordship, special sale has been created.
And one is disposed of. Will. Yes. What is this then?
Lordship,
This is what is this? Another item of Mr. Kyle is there.
No, no, Lordship, that item 55.
4487. PA, what is this?
No, no, Lordship, this is not my case. 55, Lordship, has fixed for judgment, Lordship. We have already submitted our written argument in that case, that employee was dismissed by the Vivekananda Hospital.
Oh, no, that is there. No, no. What is about this Muzammil Hussain? This is
This is 49, Lordship.
17.
17 and 49.
Okay, fine. That we have recorded it for reserve for CAB. In fact, we have dictated only final part is there. So we have made it CAB. If possible, we will deliver it before vacation also.
My written submission.
Yes, that everything is recorded.
Much okay.
There are two recent judgments.
Yes, Lordship.
One not recent by my Lord Justice Kurian Joseph, and then he was, and recent is by Justice Padiwala. Very recent.
I have relied on judgment passed by the Supreme Court. In
Yes.
State Bank of somewhere.
Yes. Next case. Smith, Musumi. To dispose of Korelu. Keep it there. It order horrible. Then item number. Yes, Goswami.
Yes, ma'am. Here, three prosecution witness examined till now, my lord.
How many?
Three, my lord. Here, my lord.
What is the total
Your
witnesses?
lordship, kindly see the production list case, my lord. There, your lordship.
Give the both the cases.
Because there, your lordship has called for, because regarding merit, my lord, your lordship has not heard, but the lordship has called for a report regarding taking up the cases, my lord.
No,
But-
that will
yes,
pass.
Yes,
That will pass because
otherwise, my lord, 3 witnesses examined, my lord, 1. It has one first.
scan copies are there.
Scan copies are there, my lord.
How many total witnesses?
As total kiman আছে? I have, the records are not before me.
Okay.
Lordship, matter may be taken after time, so sometime lordship,
After vacation?
at two lordship. Engage it.
Because that will be better because one report,
That's right,
report
but-
will also come, my lord, if after vacation, because there is a report.
Okay, let us see. Where is the affair?
Page to-
Lordship, page number 9, lordship.
Page number
Relevant
9.
Person, page number 11, lordship.
আমার তো নাই। List over নাই, list of নাই যে।
What is the recovery?
মানে Java tablets। হয় না?
From the possession of whom this earlier rejected by this court or what?
That's because my this case is not listed, my record is not before me.
Okay, this was rejected.
That is why it came. Yes, my there is an order. For,
Now I recall these two
for-
boys. Position was
yes,
clearly there. After that,
speaking-
how many witnesses examined?
One.
Okay, they are maybe in difficulty because they are also listed, today listed. When should we fix
Maybe take about 2
At two lordship.
at 2 p.m.
at 2? Okay, let us see at 2. Okay, cool. Okay, these two matters will call at
Yes, ma'am, that will be.
better, let them also come. Kima? Yes,
Today is 90 days left.
90 days.
Yes.
Third sheet file? No, CD is
No.
with it. Hard,
Yesterday's case. Ma'am.
Mr. Swenso, this is an application under section 439 CRPC. The petitioner was arrested on
He was forwarded on 27 also. 27/3. 27/3.
he has been in custody since 27/3/2024. Today is what is the date today?
Today is my lord 25th, 25th.
Then how can it be 90 days?
I have calculated also. 90.
Because in my lord,
30
in March, my lord.
Yes, that calculation you are good. Yes.
And other co-accused.
Case
also-
diary is produced, perused the same. It is seen that investigation is
Going on.
almost at the final stage. However, no charge sheet has been filed and the petitioner has in the meantime been in custody for since 90 days. First of considering that it will be a default bail,
No, my lord, on the 91st day, it will
91st day. First of considering the period of detention and the stage of investigation, this court is of the view that no further custody of the petitioner shall be necessary, accordingly allowed to the satisfaction of
be inspection of the
to the satisfaction of
CGM Kamrup.
CGM Kamrup or before the special judge, say for CGM Kamrup.
My lord,
Pokso, let's say.
is Poxo.
Special
Special judge, my lord, it will be.
That is
sorry,
right,
that is
special
right.
judge
Yes.
Boxo
Poxo
of
is-
Kamrup,
Yes. Kamrup Metro.
Kamrup Metro.
Highly please.
Again, my lord, Diwali is coming, so yesterday. I warned my lord.
Yes. Oh, that case.
Yes, that case.
Alina
my lord.
bail issued no. Same.
Same case, that case.
That co-accused granted bail Mandal Ali.
Mr. Nath has taken, just go into. Do you remember the number?
BA number I have lordship, 1187.
No, 1013
That is
number.
1 AB, my lord.
10?
Yesterday is AB.
13. Okay. You
is
just
NDC
give
that
that
is-
order. Here it will be the BA only.
Yeah.
We have seen that.
Yes.
That is AB lordship.
But beware of the Diwali.
That's.
Yes. Yes, next.
May it please my lord.
Yes,
My lord, as per the interim protection granted on 8.
yes, Bothakur,
Yes, my lord, case diary
after a
received. my
long
lord.
time, you have been
Yes, my lord.
visible.
Yes, my
Yes,
lord.
all is well.
And now, my lord.
Yes.
My lord, in this case, interim granted on 6/6/24.
Hmm.
CD is up to my lord 1/6/24.
You want updated case diary, you want his custody, or will dispose it of?
Your lordship may dispose it of my
Dispose it.
recording his statement that he appeared on such.
Okay, appeared on Swenson, so appeared before the IO, considering the case diary produced everything. Huh? He will again go and appear, or you have appeared?
I have already.
Set on my part, my lord. I think the steps
Okay,
to be, my lord.
Mr. Mojumdar, counsel, learned counsel representing the review petitioner submits that due to inadvertent steps was not taken, and same will be taken within a period of 3 days from today. Accordingly, matter stands adjourned. Subject matter stands adjourned. Steps be taken within a period of 3 days, and may matter be listed after 4 weeks. Interim order pass earlier shall continue till the next date of listing. Give a date after 4 weeks. 31st of July. Mr. Mojumdar, there is another case. What to be done today? CAV is a difficult proposition. Vacation, huh?
Actually, we had already given all the arguments, written arguments, the law, everything I have placed here.
I asked you to give a note. Have you given that?
Yes.
Be
Given
there-
with the judgment.
If you are not busy, be there for some time when matter is closed.
I know.
Yes.
I know. With the sections, everything quoted I have given. They should
Then
be
we'll make it CAV.
Yes.
Because I also recorded the note. So then on last occasion, you were not there.
I was
That's
on my
why
list.
we thought that we'll do. Okay,
I'll place-
we'll
I'll place that argument and you can have it
okay,
finished.
we'll make it CAV. Yes.
Actually, this petition is pending for last 8 years. And during that period, I failed to convince the honorable courts that there cannot be any exchange of pleadings in order to ascertain the correctness of the judgment already passed. At the highest, my lord, one can go for appeal and review, my lord. That was not done, my lord, at and finally. And Lordship is very much aware that the so far,
What is this contempt is against what?
my lord, non-payment of salary,
Now, where is that order?
my lord.
Where is the order?
My lord. I think, my lord, page in contempt petition number 522, page 23, my lord. Paragraph
Page
5.
23.
Paragraph 5.
Just a minute. Page 17 is the affidavit. Yes, sir. Who is representing the contempt now? Mr.
Let's see.
There is an order on January 2024.
Lordship, what has done, my lord, during the pendency of the suit, my lord, one of the petitioner, my lord, expired. He was suffering from a cancer patient.
Okay.
And Lordship has given time for,
To get it implemented. Okay.
of finding a substitute petitioner. What has happened, my lord, we have already informed, my lord, that the person is, my lord, the husband, my lord, is a cultivator was removed place, and during that period, my lord, all the district administration giving preference to the election related works, my lord. That is under process, my lord, but death certificate was obtained, my lord. So for masking certificate and legal error certificate, my lord, not yet
Now,
obtained, my
today, what are you expecting?
lord. My lord, that apart, my lord, another thing, my lord, they have filed 2 affidavit, my lord. And we have filed reply also, my lord. What has happened, my lord? Kindly peruse the order dated 11/4/23, my lord. That is not in the record. Due to that, my lord, it is difficult to make one presentation, my lord, and it will not be convenient for your lordship.
11/4.
11/4/23, my lord. We have served the copy, my lord. We have filed a reply, my lord. That was not in the record. So for earlier occasion, I remember, my lord. And
Now,
court has
whether it
served
is on record
11/4/20. That is not in the record, my lord.
today also.
So, my lord, lordship has to
These are series contempt or what?
That was earlier, you could see.
It was in a big series with all the Dhemaji, Lakhimpur, Shivsagar, everybody was together.
It was
Then it was
segregated.
segregated. All cases were.
11-4.
11-4-23, my lord.
There is no order of 11-4. 22-5 is there. 8-5 is there.
Or I can be allowed to read out it, my lord.
70-20-23, list after 3 weeks, then 8-5.
This is order, my lord. I have to
11
copy,
to
my lord.
11-4.
I will be allowed to read out, my lord.
Yes, give me a copy.
11-4 year order नहीं
नहीं
क्यों है अपने घर बनाए थे
I think this will be in 1-8. This order is in 1-8. Which case? 4-6-1-8. Therefore, it is not available here. Your case is 5-2-22. This is passed in 4. So, which petitioner? Therefore, it has been segregated. Did you file any affidavit in this case? 522.
Yes, they have filed, my lord. We have filed a reply, my lord. But that
Are you
our answer is available.
having a copy of your reply?
My lord.
Is it filed in 522?
522.
Just look into this,
Look it.
your petition.
Let me read dirty, my lord.
No, let it be dirty. Just read it. Yes, Mozumdar, look into this. It is filed in which?
522 additional affidavit reply 522 of 2014 filed on
The Learned Council. Yes, Mr. Mozumdar,
2018.
why this matter is pending
My
since
lord,
2014? Tell us.
There were all a bunch of matters where those the illegal appointees of Dhemajis were required to pay
Then
salaries.
committee this, that.
Either they were required to be paid some interim salary or they were final orders in both. So in some batches, there was a order for payment of interim salary. But they, at that point of time, the respondent number 9 here, the then secretary, I represented only him. So now he's retired and gone. These matters, most of them were taken up. People have been given the appointments. Most of them have been given the appointments. Many have joined. Many have refused to join.
Now,
That
according to him, what is regarding, what is your stand so far relating to these people?
Exactly his stand, my lord, I do not have on record because the person I represent is gone.
No, anything, any affidavit, any file, what is their stand in your case?
That the screening was going on was the last thing at that point of time when the person I represent was there.
Now tell us first thing, we'll go to the merit. Are you still having in contact with your client? That let us be fair. Any contact with your clients as on date?
So I have contact with your client.
They are still aggrieved. They have not been given job and all because as far we know,
He retired. He retired, my lord.
few retired, but there was a screening. Somebody were entitled, decided to. Okay, let your reply affidavit be
Two
there.
persons could not be accommodated because there was some difficulty in their school, naming of the school. Otherwise, one instruction in the group
We
says.
will require to hear this matter. That's all. The Learned Counsel for the petitioner submits that an affidavit was filed.
How many steps was in 25 over?
In affidavit in reply was filed in the present proceeding by the petitioner on
28-10-18.
28-10-18. Full stop. It is submitted by the Learned Counsel for the petitioner that earlier the matter was taken along with WPC 4618 of 2017. What happened to that case?
That was earlier even series, my lord. Subsequently, it was segregated, my lord, separate.
But this is 4618 along with 4618 of 2017.
That was the
Full stop. And therefore, the affidavit filed in case might have been placed in that case in as much as the reply affidavit is not available in the record of the present case. Full stop. In view of such submission, registry to verify whether any affidavit has been filed by the petitioner on
2018 itself.
2018, sir. We have filed, madam, that is,
No, date,
that is
date,
admitted,
date,
madam.
date,
But
date.
there again.
No, no, for verification, any date.
28, 10, 18.
2010-18 in in contempt case number 5/2020 of 2014 and put a note accordingly. Full stop. List this matter after the ensuing summarization.
Also to verify whether the newly implemented respondents, whether they have been served copies, whether they have knowledge.
Okay, registry also shall also put a note as regards service of notice upon the newly implemented respondents. Full stop. List accordingly.
The data, but another pair, that petition number 5 was expired, madam. Lordship has given time to implement, madam. What has happened, madam, during the election?
Okay,
period, madam,
Mr. The
some more
learned
time may be
learned
granted.
council also permitted further time to file application in terms of this court's order dated implement a petition in terms of this court order dated 25/1/2024 if so advised.
Public.
Yes. Yes, Mr. Halle, what happened?
I just fell down in bathroom. That is and
But two hands,
two hands the same time. I slept and
So-
in a backward stroke.
adjournment.
I have no other option. I cannot use my hands, both the hands. Over
Item
here.
number
40 and 41.
40 and 41. Have you informed the other side?
Lordship, the petition, I mean, this is the applicant was also not present. Mr. Purukasta, he has submitted a letter of absence. Sir.
Oh, that letter will not accept. It is as simple as that and will not wait for him also. 2000 meter will not accept any application adjournment except this situation you are having.
Not only this.
That is ruled out. Number one. Number two is that there is already an amicus. And amicus has done his job. He properly he has prepared his note. What are the evidence? He has already submitted yesterday. So we are thinking of closing this, but anyway, you are having a difficulty. The amicus has submitted a written note of argument. Full stop. Mr. Halloy, learned standing counsel is learned standing special public prosecutor for Central Bureau of Investigation, though is present. However, both of his hands are fractured and injured due to an accident, and accordingly, in that situation, he has made a prayer for adjournment. Full stop. This matter is pending since 2005 and was also heard at length by this court on earlier occasions. However, considering the nature of injury sustained by Mr. Halloy, Lanet's public prosecutor representing CPI, the matter stands adjourned and directed to be listed.
After vacation, any date, Lordship.
Give a date.
Both hand are fractured.
You see, or you ought to have informed, you need not to have come. Or worried that dear man, without the evidence, I will not give an adjournment.
My junior, I told her to make a mention that she is saying that Lordship is very strict, may not adjourn.
This is that.
That is the.
So I have compelled him to come to court. But 2005 matter, that's why.
Right, Lordship. I am also.
Anyway, we are adjourning.
May I please receive one item number 24. Maybe come after vacation.
Item
24.
What is this item 24? Contempt, okay.
No, if it is filed,
On the request of learned counsel for the petition, it has stands adjourned. Yes, tell us who want to go home. Tell us.
All the contempt, they have either retired or immediately.
No. He is one of the container already expired. This after vacation.
28, 29 was time implementing which was expired, my lord.
Mr. Bora, learned counsel for the petitioner, prays
28,
for an
28.
adjournment to file appropriate application for implement of the new incumbents. Full stop. Prayer is allowed. List after vacation. Yes.
28 and 29.
29. And anybody? Same.
Same.
31 and 32.
Lordship will permit me on 22 and 23 then.
22 and 23.
With the
What?
consent of the other side.
Okay.
After the
Mr.
revision.
Mojumdar, learned counsel for the
State, my lord.
state
In the review petition, I am the petitioner. In the consent, I am
seeks
the.
for an adjournment 6 for an adjournment, full stop. The prayer is not being objected, stands allowed. List this matter
After the vacation.
after vacation.
On 38, Lordship, my case.
Your case?
30, on 30.
30. Okay. Aloy's case is 30, that
30.
hearing matter, 2005 April. Okay. Yes.
May I please, your lordship.
Yes.
Lordship, in this matter, I shall have to implement the new incumbent matter.
Okay. Mr. Loskar,
Well.
learned counsel for the petitioner. Prays for 1 week further time to enable him to file an appropriate application for implement of necessary parties. Prayer is allowed. List this matter after vacation.
25.
My lord, in this matter, my lord, the arrears salary, my lord, has not been paid, my lord. Okay. So far, my lord, the period from 1/8/1995 to 28/2/2021, my lord, I have got my salary, my lord. This is the suspension period, my lord.
Now tell us, where have you taken steps on the newly implemented respondents?
My lord, I have taken steps, my lord. By the
Service is
office note,
complete. When have you taken steps?
office note dated, my lord, kindly bear with, my lord, 18/3/2024.
18th?
18/3/2024. Office note.
Thereafter you have taken steps on 27/6. Okay, 18/3/2021. What to do? What to do?
My lord, the arrears salary.
Oh, understand area salary, but if notice is not is not served, it's a contempt matter. What to be done? Because 18/3/2024 says that neither ID card nor receive back. Take a fresh steps.
Well,
in view of office note dated 18/3/2024, learned counsel for the petitioner prays that he may be granted, he may be permitted to take fresh steps upon the respondent number 3 and 4. Prayer is allowed. Steps be taken within a period of 5 days from today, and thereafter release this matter after reopening.
By registered post.
Registered post. Registered post.
Obliged.
27.
None appears for the petitioner on call. Release this matter after vacation.
30.
30 adjournment.
Agreed, Lordship.
Yes, this matter as like that other case, is not it?
My lord.
Shivsagar.
My lord, maybe excuse my lord, a mistake done by me, my lord. So for affidavit is concerned, my lord, case 14, my lord. Case 14 of, I may be allowed to this curable mistake, my lord.
What happened?
My lord, actually, when there are 18 numbers of petitioners, my lord. In paragraph 2, I have written the instant
In
complaint.
which paragraph? Affidavit?
Affidavit, page 14, Lordship.
Page 14. Yes.
I should have written over here on behalf of the other petitioners, my lord. That is my mistake, my lord. This is my fault, Lord.
The learned counsel for the petitioner submits that though the present petition is filed by how many petitioners?
18 numbers.
18 petitioners. However, the affidavit has been shown by petitioner number Robin Borua.
Robin Mohan Borua.
Petitioner number,
Robin Mohan Borua.
number.
Two.
Petitioner number 2. No, here only one petitioner.
Lordship, it is my fault, Lordship. I mean, it's my fault, my lord.
Then you'll have to, no, that cannot be.
On behalf of the others, I should.
No, you cannot. In a contempt already filed by one petitioner, affidavit is shown by one petitioner. Now, can we say that I was entrusted by other petitioners? Now, you'll have to file a separate application saying that this was mistake, but I do not think it's permissible in a contempt. Your period of limitation is over for the other parties.
Actually, it is my mistake.
Maybe.
Only my lord, on behalf of the others, that should have been written, my lord.
Here also in pleadings also petitioner, not petitioners. We could have said that somewhere mentioned that these are the 18 petitioners. On the prayer of the learned counsel for the petitioner matters stands adjourned and be listed after vacation. Think over it. There is nothing on the pleading.
I admit that it's my fault.
So had it been a case that everywhere it is stated that 18 but one petitioner, we could have said that yes, actually it is 18, but
Lordship is
nothing.
right. I'm not hesitating on that point, my lord.
Let us see after vacation. Yes, next.
Before.
None appears for the petitioner on call. Accordingly, matter stands adjourned and be listed after vacation.
56.
Yes.
Matter in respect of the area salary of the petitioner, my lord. The finance department had already accorded sanction. Now the matter is lying with the directorate, my lord. And time and again, they are writing to inspector with school seeking the proposal, my lord. And getting it is delayed, my lord.
Now what to be done today? Who is
Director may be insisted, my lord.
Who is representing? Director is a respondent here.
Respondent, director is the respondent.
Who is representing director?
There is nobody by now. my lord.
Any name shown? For director, who is the respondent number? Director is? Respondent number?
That's one number 2, my lord.
Who is representing respondent number 2? Oh, he is long gone.
Long bug. Presently, my lord, they are writing. The correspondence I have.
No, understand, but you will have to bring to therefore there now nobody is there. You bring it on records or file an implement petition.
Present director.
Yes.
All right. I'll do it.
The learned counsel for the petitioner submits that he may be granted 10 days time to implement the present director
No.
as the respondent, inasmuch as according to the learned counsel for the petitioner, the finance department has already made sanction for payment. However, the director has not yet paid the arrears of salary. Full stop. Be that as it may, prayer for adjournment stands allowed. Full stop. List this matter after vacation. In the meantime, the petitioner may file appropriate application.
Much obliged, ma'am.
Take.
57.
Yes. Yes.
This contemplation was arising out of.
Oh, that we understand why this matter is listed today. Whether name of D. Soikia, B. Kaushik and N. Bordole shown in the cause list. Yes.
Maybe this is Lordship on behalf of.
Yes, Mr. Kaushik.
But we are awaiting instruction, my lord, in this.
Okay, Mr. B. Kaushik, you have recently been,
Yes, my lord.
Mr. B. Kaushik learned the counsel for the respondent number 2. And who is for respondent number 1? Its name is shown of D. Soikia, senior advocate.
My lord, I can represent, my lord.
Okay, Mr. B. Kaushik appearing on behalf of respondent number 1 and 2 submits that 10 days time may be granted to obtain instruction and file affidavit. Prayer is allowed. List this matter immediately after vacation. In the meantime, affidavit may be filed on behalf of respondent one. List accordingly.
38, my lord.
Yes, Mr. Goswami.
Notice on leave the respondent has been complete, but affidavit was not.
Leave to the respondent.
Mr. B. Kaushik, learned counsel, has entered appearance on behalf of the
Respondent
newly
number 5.
implemented respondent number 5, and he seeks for an adjournment to file his response. Mr. Goswami has expressed some urgency as this matter is pending since 2017. First of
Order is 2016.
and
Not
first
getting
of
surrendered.
2017. In view of the aforesaid, let this matter be listed immediately after ensuing summer vacation. In the meantime, let the respondents file their response.
My lord.
Okay.
May I please, the Lord.
Hmm.
The Lordship heard this matter on 26.
We are. Yes, Goswami.
Lordship. Here, Lordship, and arrested on my lord 15/5/22 as per the record, my lord. And search sheet was on 29/7.
Just 15.
15/5/22.
Earlier you have rejected, no?
Earlier rejected, my lord. Which I requested that it may be taken up within 6 months. my lord.
Then
And CS file on 29/7.
15/5 is the
Arrest, my lord.
arrest.
And my lord search sheeted on 29/7.
29/7/2022 search sheet.
Charges are framed on 14/11. 22.
Sorry.
Lordship.
14/11/2022
22.
search.
Charges were framed. Thereafter, my lord, evidence, my lord, trial began, my lord. And till now,
Till now,
3 witness examined out of 14. 14 also, no?
out of 14.
One official witness, 2 seizure witness.
What the seizure witnesses say? Seizure witnesses affirms because
Seizure witness affirmed. And PW3 also witnesses, my lord, trustworthy, my lord, though official. my lord.
who is PW3?
Official witness, my lord. He is a part of the team. my lord.
Okay. Now who are remaining?
Remaining another official, some persons are there, my lord.
Why you need so much 14 witnesses?
That is the difficulty. It need not be, my lord. 6 or 5 or 6.
See, in a NDPS, who has followed the procedure and who is a part of the system procedure, section 50 or whatsoever,
Yes.
they are the witnesses.
6, 7 male.
And independent seizure witnesses they are important. Then second part is to affirm whether contraband is actually contraband. FSL. That's all.
Some cases, my lord, FSL expert also not called. That is also permissible.
Permissible.
But my lord, anyway, my lord, 14 they have cited, my lord.
What is the next date?
Next date, my lord.
It is not clear from the, because it is earlier it was called for, my lord.
After vacation.
My lord, my submission, my lord.
No, we understand your submission, but problem is, see, difficulty is this.
Para 11 of my, your lordship, last order, my lord.
We understand.
Para 11,
We understand. See,
Earlier-
apparently there is a finding of this court that possession is, will not say possession is established, but prima facie on the material, it is according to us, possession is established.
My submission, my lord, seizure witness is not exactly affirmed that. Not
No,
exactly affirmed.
that is a debatable, but we cannot make a convincing conclusion that possession was proved or not proved. Prima facie, in our view, subject to further. Because at this stage, we'll have to, our satisfaction is to that extent only. We cannot make a conclusion that either you can be surely convicted or surely not convicted.
My lord, 8/11, my lord.
What is the next date?
Next date, my lord. I have to inquire, my lord.
We are taking immediately after reopening. Okay. We'll consider on that date. This and other matter is we are just, we'll pass that order also.
Yes, sir.
We have asked the Director General of Police
Yeah.
to have some clarity on
Yes,
this.
yeah.
So therefore, this case we have tagged along with this.
Alright, my lord, then my lord, July also is coming, my lord.
Therefore, after vacation,
Yes,
we are
then
fixing it. Okay,
something-
we'll pass an order. We are not rejecting at this stage. We just keep pending for the next.
Some
And if
point-
you want that you need an or an order should be passed, we'll pass this order.
Lordship, your lordship, I live with your lordship.
That order was.
On
We'll give a
July.
date. Order to already dictated. First part is dictated, only bail will pass on. Yes,
15/7.
15, 15 or maybe 16, 17 something. Yes.
For admission, item number 12.
Potakor. A bundle of that. One more CAV.
Lordship,
One more CAV.
I have prepared the note, your lordship. Everything is there.
Everything is there. Give me the, where is that note? Musumi Dakha. Yes.
As far as the facts are concerned, your lordship, going by the death case of the petitioner, your lordship, this is, your lordship, can be categorized as maternal death, your lordship. There is no doubt about that. Going by the pleadings of the petition, there is also.
Now, what do you say about the stand of the government?
In fact, your lordship, what government has stated. They have not denied, factually, they have not denied, your lordship. Only thing, your lordship, they have said.
It was a
Cannot fix
moderate
your lordship.
anemia, is not it?
Lordship.
Initially, it was moderate anemia.
Whatever it is, ultimately it's a maternal death, your lordship. Now, your lordship, one aspect is there, your lordship. If your lordship go by this particular, the guideline for antenatal care and skill attendance at birth, your lordship, issued by the central government, your lordship, which governs the functioning of the ASAs, your lordship. Your lordship will find, your lordship. If your lordship takes up my note, your lordship.
Just a minute. Yes, which one, Mr. Abatao? Your note.
Page 4.
Yes.
This is the, your lordship, guideline, your lordship.
Of the guideline, which one?
Guideline is there, your lordship, but your lordship, I kindly come to my note first. Your lordship.
Yes. Space?
Page 5, your lordship.
Yes.
Last, your lordship, point, your lordship. Bullet point.
Most of the
maternal deaths are linked with 3 types of disease, which can result in an increase in maternal morbidity and mortality. They are these, your lordship. As per that, your lordship.
As far this guideline of the.
Now, your lordship will find, your lordship, key messages at the page 7 of the
This
scheme.
compilation scheme. Okay, scheme. Okay.
Scheme will be. Now, your lordship, here it says register every pregnancy within 12 weeks, track every pregnancy by name for provision of quality ANC, skilled birth attendance and postnatal services. Now, if your lordship comes to page 9, there is a specific provision for counseling of the pregnant woman, your lordship. Help the woman to plan and prepare for birth. This should be include deciding on the place of delivery, advantage of institutional deliveries, risk involved in home deliveries, advise women on where to go if an emergency arises, how to arrange for transportation, money, blood donors, educate the women and her feminine signs of labor and gender signs, emphasis on importance of seeking ANC and PNC advice and diet. Now, your lordship, most important, your lordship will next page, your lordship will file. Keep a track of all pregnant women by name. A duty is cast, your lordship. As the ANM, you must refer to your register to keep track of all pregnant women in area. In case a woman who is registered with you does not return for her antenatal checkup, then she must be followed up at her home and counseled go for regular antenatal checkups. And it is very likely that women might not come for ANC early in their pregnancy. You should take the help of AWWs, ASAs, concert numbers, and so on to track pregnant women who have not come to their antenatal checkups. Once such women have been tracked down, arrangements should be made to give them ANC as soon as possible. These women should also be counseled for the importance of complete ANC for the better health and health of the baby and the mother. Then your lordship may kindly come to page 21.
Of your comparison.
Role of ANM and MO. It was to be found in page 31 of this scheme, your lordship.
Yes.
These are the role assigned to ANM and medical officer. Detection of anemia by blood testing for HB. Provide IFA tablets to the pregnant woman as per GOR guidelines. Treat pregnant woman with the mild to moderate anemia. HB estimation after a month of starting therapeutic regime of treatment and reassessment to continue or modify the treatment as per GOR guidelines. Counseling of pregnant women on the common side effects of IFA supplementation general needs associated with taking of IFA tablets related risk anemia not to be treated. Dietary counseling for pregnant women. These are the your lordship things to be done and specific role of ASA, your lordship. ASA is the your lordship direct contact between the institutional authority and the pregnant woman, your lordship. Preventive IFA supplementation to every pregnant woman, identification of anemic women during pregnancy and postpartum period to routine and outreach activities of so and so, bringing these identified women to institution for diagnosis and treatment. Ensure regular intake of IFA treatment for anemia as advised by ANM, MO, specialists, etc. Ensure follow-up visits by pregnant women at the scheduled time to the health facility, outreach activity site. Provide appropriate and supportive care for anemia. Counseling pregnant women on the common side effects of the IFA supplementation, general meat associated with intake of IFA tablets related risk of anemia not treated. These are the your lordship specific role assigned to the then specific role is also assigned to ANM, then MO, your lordship. Now, if the authorities go by this provisions, your lordship, then probably this kind of death
Will not
could
happen.
not take place, your lordship. But here, your lordship, as what has been revealed by the pleadings, your lordship, seems to have that those facilities are not provided to the woman. And more particularly, your lordship, there are other schemes also, your lordship. Janani Shisu Suraksha Karjakam. This is also important, your lordship.
Which one?
Page 25, your lordship.
You're not.
Page 25, your lordship.
Just a minute. Janani Shishu Suraksha.
The scheme entitles all pregnant women delivering in public health institution to absolutely free and non-expense delivery, including cesarean section. Under the scheme, a pregnant woman would be entitled to free transport from home to the government health facility between facilities in case she is referred on account of complication and also dropped back home after 48 hours of delivery. Entitlement would also include free drugs, consumables, free diagnostics, free blood, wherever required. Now, your lordship, probably your lordship, going by the pleadings, your lordship, I don't know, your lordship, whether your lordship pleaded case is correct or not, but going by the pleadings, your lordship, she has not got the blood, your lordship, free, and she has to have to pay your lordship rupees 300 per unit of blood.
Let us see the stand of the government on the pleadings.
Before that, your lordship, I will just
Yes,
place
yes.
one more, your lordship. That is, your lordship will find there is a your lordship Your Lordship may kindly come to page 30. I have Your Lordship annex this also, Your Lordship. State government has signed and Your Lordship some memorandum of understanding with the tea garden. Now, this is PPP with tea garden hospital. Sir. And for this, Your Lordship, apparently, this has, we have downloaded it from
Where
the-
do you get this PPP concept in this? Is it available here?
Yes, Lordship. I have.
Just give me the page in the. Now we have given page 3 and all. Is any page in this record?
Your Lordship, last, we have marked the last note, Your Lordship. Absolute last.
In page 30, you have given PPP, but prior to that, all page numbers are there. Page 9.
Yes, we have not.
Just let me know. I'll just mark it the page number of this book.
Last 4 pages, Your Lordship, of the note.
No pagination. Okay.
Last
Okay.
4 pages. Pagination to wait for the question. Your Lordship got it, Your Lordship.
Yes.
PPP with the garden for tea garden hospital. We have downloaded it from the government website. Your Lordship. Now, if Your Lordship will find that there are rupees 10 lakh was allocated to each tea garden hospital as central assistance under PPP. Your Lordship. As per norms, the fund is released 2 installments. First installment signing of MOU, second installment is being released after submitting UC and first so and so. Now, these they are required to Your Lordship spend. One of the focus area for this is, Your Lordship, to provide maternal and child health care, Your Lordship. Now, ultimately, Your Lordship, there is no mechanism to verify,
Monitor.
whether that amount has actually been spent on this or not, Your Lordship. Therefore, Your Lordship, even in case of working of the ASA, there is no monitoring mechanism, Your Lordship, available. That's how, Your Lordship, probably, Your Lordship, a monitoring mechanism and a grievance redressal system.
Because it also says tea garden hospitals are required to send monthly reports
Lordship.
on physical progress of key deliverables and financial achievements in a format prescribed to NHA Assam.
And Your Lordship, one more, Your Lordship, study undertaken by the National Health Mission, Your Lordship, that is not part of that, Your Lordship. Your Lordship will find the situation in the year 2016, this study was conducted, Your Lordship. Subsequently, I got it from the website of NHM, Your Lordship. It shows, Your Lordship, that the situation in the tea garden areas are very green, Your Lordship. And Your Lordship will find that study on the contributing factors of IMR and MMR in tea gardens of Assam 2015. Your Lordship. And this study shows, Your Lordship, if Your Lordship will get the page number at the bottom. 4. It starts from 4. Tea Garden Hospital finding majorly comprised of the available facilities in the tea garden hospitals. Then 6, Your Lordship, may kindly come. From the above table, it can be easily interpreted that only 22 doctors are available out of 36 tea gardens where permanent worker is more than 500. As usual pattern, numbers of doctors are decreasing as workers are decreasing. 182 of 281 facilities have A&M, 191 facilities have pharmacists, health assistant. It is also found that total 345 assets cover 244 tea garden hospitals. Then next page. Mothers in the tea garden life, the finding comprise of the health seeking behavior of the mother.
Any study thereafter?
No, Your
Because
Lordship, I have not found, Your Lordship.
because see thereafter they have that
Yes.
regarding health they have taken some measures. We will not say that government has not done anything.
No, what I am trying to point out,
no.
that the situation was very grim at that
Grim
point
at
of
that
time.
point of time.
And in fact, these kind of maternal deaths can take place, Your Lordship,
In that situation.
in that situation.
Togo will help us. We're not closing it. Initially, I thought I'll close it.
Yeah,
Uh,
so far as whatever statement.
See, don't take it as an adversary litigation. Adversary.
Refer to the
See,
various schemes.
keeps, no.
But to my lord, to establish that matter because of some fault of the authority, the incident happened. There will have to be definite proof for compensation because
No,
the player is
let
only
let us not go to that for a time.
But-
Let us, that compensation,
That
that will a different issue,
On
but
the point of compensation, Your Lordship, I have one
In a
submission to
broader-
make, Your Lordship, that Your Lordship, whether compensation will be granted to the petitioner or not, will have to be looked into the fact that, Your Lordship, the girl who died, she was, Your Lordship, minor at the time of
Yes.
marriage, Your Lordship. That's the
16
one
years,
factor that will have
16
to
years.
be considered, Your Lordship. That has-
pregnancy at the age of 16, that can be an additional factor, No, we are,
These are
who is for the petitioner here? You are as an amicus? Okay, you are petitioner. See, one guy, one lady is died, that is one aspect of the matter. Other aspect is that, larger that it should not happen. Compensation is one part of the story. Other part is, we may like to have what is the present status so
Yes,
far
yes.
relating to tea garden. See, suppose a state is financing a hospital, private hospital.
Yes.
Okay, we'll
PPP
say
mode, my lord.
PPP
Private
mode, but
public partnership.
public
Yes,
partnership,
yes.
but even then,
My lord.
a taxpayer's money are being paid
Yes.
to an individual hospital
It should go
for
in the right
interest of the citizen.
Yes.
We cannot doubt the wisdom of the state.
So far the
Apparently,
policy is
so
that-
far
yes.
the contribution. But at the same time, we'll definitely ask the state how they are monitoring that whether this amount is properly used or not.
Yes, sir.
Is that it?
My lord.
And we'll definitely like to know what is the status after 2015. There may be very good situation, we do not know. It is improving, no
Because
doubt,
there are other
no doubt,
countries
but
also.
how you are doing? So we'll fix it. Initially, I thought that I'll close this matter and keep it as a CAV and pass the judgment. But looking into all this, let us have some, wait for some time further. I'll pass an order. You will online it by Friday.
Lords.
Small.
Is required from our side
That-
regarding
that is-
implementation of the scheme.
See,
So you may kindly mention it, my lord.
That is what we'll seek for a time, for a time being. If anything, we can do. Okay, we'll pass the order.
Deeply obliged.
Who are appearing for whom's a scheme? একটু রাখি এটা, হ্যাঁ। হেরি পিছনে একটা ডেট দিবা। এটা চেম্বার ডিটেইলস খালি পড়া কি মানে ডিমার্কেশন আজকে ফাইল না দেখ। Where is your note?
Starts with the
Relevant provision of the Central Reserve Police Force.
These are the provisions which could be referred to. Section 2D, which defines a member of the force. 6 member of the force. 16 period of service. Then the training part. This petitioner was harmed in training. Then my lord will find.
Let us record the facts first. Then we will go to the other parts. That is already there, you have prepared. Just let us record it. We may not dispose of to pass the judgment today. Hard. Mr. L.R. Majumdar for the Learned Council for the petition. This court, taking note of the importance and complexity of the issues, requested Mr. Majumdar, Learned Council, to assist this court as amicus. Accordingly, Mr. Majumdar has advanced his argument. Full stop. Before adverting to the arguments of Mr. Majumdar, let this court first record the background facts in the present case. Pursuant to a selection process, the petitioner was offered appointment to the post of constable within bracket general duty in CRPF. Full stop. When he joined,
11/1/2011 he joined.
But there was a, I think something, okay. On 11/1/2011, the petitioner joined at Dayapur, Silchar as constable within bracket general duty CRPF. Full stop. During the course of training, isn't that it?
Yes.
During the course of training on 22/12/2012, the petitioner sustained injuries on left leg or hand?
Left knee.
Left knee. Left knee. While undergoing training at NIMUCH and MUCH, Madhya Pradesh, the petitioner sustained injuries on left knee, and accordingly he was admitted at Composite Hospital, CRPF, NIMUCH and MUCH. Subsequently, he was referred to Composite Hospital, New Delhi on 30/12/2011, and thereafter on 14/1/2011 he was referred to Safdarjung Hospital, New Delhi for better treatment. Subsequently, after certain treatment, he was again admitted, released from Safdarjung Hospital. However, he continued to be admitted in Safdarjung Hospital, New Delhi since 23/1/2012, and finally he was released from Safdarjung Hospital on 9/2/2012. Full stop. On just correct me if I am wrong on facts, Mr. Mehdi, you too, huh? On 26/3/2012, the petitioner was issued a fitness certificate to resume duty, and accordingly on 8/6/2000 duty he joined the duty. However, once again on 8/6/2012, the petitioner was referred to Composite Hospital, New Delhi for further treatment. And after treatment in the Composite Hospital as well as in the Safdarjung Hospital, once again, petitioner was released and fitness certificate was issued on 15/9/2012. Full stop. Due to recurrence, he was again treated at Composite Hospital on 6/2/2013, and finally, and thereafter, he was released and a fitness certificate was issued on 26/8/2013. It continued like it continued in that manner, and finally, on 10/2/2012, and thereafter, the petitioner was referred to a medical board, and on 10/3/2015, medical board opined that the petitioner was not fit to undergo strenuous and rigorous physical training. Accordingly, by an order dated 27/4/2015, the petitioner was terminated from service as per Rule 5 within bracket 1 of the Central Civil Services within bracket Temporary Services Rule 1965 within bracket hereinafter referred to as Rule 1965. The petitioner represented before the authorities against such termination, and finally, having no alternative.
Amendment order is rules.
Huh? What amendment order?
Amendment office order, rule 6, number treated rules.
When it was issued?
It was 42 pages.
No, tell us the date.
It was
10/6/15.
10/6/15.
Initially, they terminated him under Rule 5, amended to Rule 6.
Yes. Subsequently, the termination order was amended to be an order under Rule 6 of the Rules 1965, which was issued on
10/6/2015.
10/6/2015. তাৰপিছত দিলে না, represented before the authorities. Finally, the petitioner approached this court by way of filing WPC number 4498 of 2015, which was disposed of by this court on 25/2/2020. Isn't that it?
25/2/20.
2025, with a direction to consider the case of the petitioner in terms of
Pending order.
standing order
4/2011.
4/2011.
Amended till 14/8/2012.
Okay, amended till, within bracket,
14.
amended till
14/8/2000.
page
That is a page 86.
86. Full stop. লিখি থওঁ পিছত চাওঁ। Thereafter, in terms of the aforesaid order of this court dated 25/2/2020, the petitioner was asked to appear before the Departmental Rehabilitation Board by an order dated 19/6/2020, and the petitioner reported for such before the Rehabilitation Board on 7/7/2020. After examination of the petitioner by the order impugned in the petition, impugned in the present petition dated 14/9/2020, the case of the petitioner was rejected for rehabilitation under the rehabilitation scheme. Being agreed, the present writ petition is filed. Am I clear?
Only thing is, well, it is direct to refer the case, not consider. Page 85, of this earlier judgment, paragraph 8, therefore, this writ petition is disposed of with a direction to the commandant of the so-and-so responsible to refer the case of the petitioner to Departmental Rehabilitation Board.
That's right.
Yes,
Dispose of that,
Yes.
same thing, dispose of the petitioner for consideration.
And thereafter, if suitable, then to consider,
So to consider his case,
Yes.
it will not go so details. Full stop. Mr. Muzumdar, learned counsel, learned amicus. Come on, where is the order, Mr. Muzumdar? Impugn order?
That should be find it. 87, my lord.
87. By the impugn order, the medical board concluded that completed the following, while rejecting the claim of the petitioner, the board, rejecting the claim of petitioner, the following reasons were considered, or following reasons were cited.
Not by the medical board.
Not medical office order.
DRB,
We'll correct that. Just we are going fast so that just to record.
Yes.
We'll later on deal with every papers and we'll correct it. That on the following counts, rejected on the following counts: A, that the petitioner has not completed his basic training and he will not be able to complete his basic training in future, and he will also not be able to take any strenuous work inasmuch as CRPF is highly active and mobile force where he has to take lot of physical strain even for leading normal life in camp. Therefore, full stop. Full stop, full stop. Next, 2. The petitioner himself agrees to the aforesaid physical condition and requests for some monetary compensation, comma, which is not permissible under rules. Third, after examination of physical and mental ability, comma, aptitude, comma, job requirement, etc., the petitioner is physically not fit to be rehabilitated for any subsidiary role of CT/GD under the given rules and regulations. First of all, Mr. Mozumdar, learned amicus, referring to the section 2 within bracket D, contends that a trainee can also be treated as a member of the force in as much as member of the force has been defined as a person who has been appointed to the force by the commandant in as much as the petitioner was appointed by the admittedly the petitioner was appointed by the commandant. Full stop. Mr. Mozumdar further refers to Rule 6 of the rules. Which rule? This is CRPF rules 1955. So CRPF rules 1955 that member of force shall be deemed to be the member of force. Officer mentioned in Rule 5 concludes that officers and men mentioned in Rule 5 shall be deemed to be members of the force. He further contends that a temporary person, trainee like the petitioner, can also be treated as a member of force in terms of Rule 16, where it is prescribed that all members of force shall be enrolled for a period of 3 years. Therefore, a temporary appointment for 3 years is also a member. No. Referring to Rule D of Rule 26, Mr. Mozumdar contends that the period of training shall be treated as duty for all purposes under FR 9 within bracket 6 within bracket B within bracket Roman I. Therefore, in this count also, the petitioner cannot be deprived of his right. Referring to Rule 52 of the rules, Mr. Mozumdar contends that all members of force on duty or on duty with a military force are entitled to own, injury or family pensions or gratuities as laid down in Civil Service Regulation and Central Civil Service within bracket Extraordinary Pensions Rules 1933 as may be 1993. Therefore, on this count also, the petitioner is entitled for benefit. Full stop. Per contra, Mr. S.K. Medi, learned counsel for the union, submits that the present writ petition is not maintainable as the petitioner has not challenged the termination order. And in absence of such challenge to termination order, the petitioner cannot be granted the benefit as claimed for. In this contention, Mr. Medhi relies on the decision of the Honorable Apex Court in the case of Mukul Saikia and others versus State of Assam and others reported in AR 2009 SC 747. Full stop. Mr. Medhi further contends that in terms of government office memorandum dated 4/8/2017 issued by the Government of India Ministry of Home Affairs for cases with disability and payment of ex gratia lump sum compensation, minimum 20% disability will be the considered condition for grant of ex gratia lump sum compensation. And therefore,
My lord,
therefore what?
it is,
Huh?
therefore, this honorable court may remand this case.
And therefore, he contends that this court may remand the matter once again to the employer so as to determine the entitlement of compensation under the aforesaid office memorandum, inasmuch as the petitioner is not entitled for any benefit under the rehabilitation scheme, as he was not a member of the force at the time of accident, and he was only a trainee and his training was not completed. This is your case? That was your argument all throughout.
But this.
No, not but.
Yes,
Why we have asked Mr. Mozumdar? Because of your argument.
Yes, yes.
This was your argument.
Yes, madam. But the main thing is now, madam, if suppose he is in service, madam, his appointment is as per the, then madam, this may be sent to the department, madam, for the board, madam, and considering how much compensation he will get, madam.
That is what we have
Yes,
recorded.
yes,
That
yes,
is your case.
yes.
This is your case. Heard the learned counsel for the parties. Hearing concluded, reserved for judgment.
And only, madam, oath was not taken, madam. This is the.
You want an oath?
No,
What is the
madam,
purpose of oath? We have already delivered a judgment so far relating to oath of office by chairman of APS Arunachal Pradesh. It will late. Mr. Medhi further contends that neither the training was complete nor oath was taken by the petitioner in terms of service, extent service norms and
rules of
extent in terms of rule
109
rule 109 of CRPF rules 1955, and therefore by no stretch of imagination the petitioner is entitled for a benefit of rehabilitation under the rehabilitation scheme, inasmuch as rehabilitation is meant for the member of force, not for the trainees.
My arguments, Lordship, will find it page 3 onwards.
Okay.
On page 1 and 2, I have only given those
Just
sections.
I have therefore I have just recorded.
Three is only what I would like to. I'm obliged. Madam.
After vacation, these are for vacations. Others will sleep. We will write judgments. Yes.
Extraordinary pension rules, my lord, ER 1939, is 93 recorded.
1939. We'll look into all this.
Remand it back, my lord. Finally.
I have recorded.
Yes.
Don't be so egoistic.
No, my lord. No, this is my submission.
Please, your lordship, my lords, ultimately I have received my notes and that is sent for the chief secretary for approval. And now personal department and judicial department and this office of the chief secretary, they have held a lot meeting and discuss, and the minutes is there. On the basis of that, I will find everything.
Okay, Mr. Sutia, learned counsel representing the state, submits that in terms pursuant to this court's observation recorded in pursuant to the observation made by this court under its order dated 11/12/2023. What is meeting has been held between
the personal department, judicial department and
personnel department, judicial department and chief secretary.
Yes. Personnel, judicial, and revenue.
and Revenue Department.
Yes, madam.
And accordingly, minutes have been prepared and same has also been approved by the,
Not approved, sent for approval.
same has been sent for approval of the
Chief Secretary.
Chief Secretary of to the state of Assam. And the entire affidavit shall be filed on the basis of
That minutes.
the minutes, and therefore he submits that he will be able to file the affidavit by second week of July 2024. Full stop. Accordingly, he prays for an adjournment.
My lord, I pray that the records may be called for because the anomalies which your lordship has observed, there is an anomaly and there is a possibility of choose and pick. Now, as far as the
Your case
state-
is that only.
yes, Lord, sir. But what happened is the candidates who has been selected here, there is no mention when their application were there. And
No, we'll seek on the next date. Okay,
Okay.
just remind us.
Yes.
Let us see how they respond to it. Then we'll seek. Okay.
Yes.
List accordingly on second week.
Second week of July.
Okay.
Reopening, no? July.
Mr. Sutia, you file it by the next date.
Definitely, because assistant request, I have received it. On 24th July.
24th of July.
placement.
Yes, Miri.
Well, it is 100 and not 109, only 9 minutes. Only 9 minutes.
Nine.
Okay.
Natak Kulala. Instead of 100 of rule 100 of 9, it's 9.
Obliged, my lord.
Yes, Bothakur.
Yes.
Food Safety Act.
Earlier, my lord, your lordship has asked regarding on the contents of the FIR, my lord, foundation of the case regarding initially suspected that this is buffalo meat. And my lord,
Our issue was when an FIR is registered,
yes,
when a cognizable offense is made out on
Yes,
the
ma'am.
basis of an FIR.
yes,
Here, what is your allegation in the FIR?
that suspected in the name of buffalo
So
meat.
suspected
Yes,
meat in the name of buffalo, they are selling beef.
yes.
Now, what is the offense there?
My lord, here, my lord, here,
According to you, what is the cognizable offense made under IPC or any other?
yes, my lord, as per the, my lord, your lordship has, my lord, has already gone through the section 8 of the Assam
this is
Cattle Preservation Act. my
Cattle
lord.
Preservation Act.
Your lordship may kindly come to section 8 of the
Cattle Preservation Act. Yes.
prohibition on sale of beef and beef products. My lord, it is admitted fact that beef products are also consumable, my lord, items, my lord. So knowing fully well that those beefs are also consumable item, this my lord, provision has been, my lord, inserted in this particular act, my lord. Prohibition on sale of beef and beef products. No person sell directly or indirectly sell or offer or expose for sale or buy beef or beef products in any form, my lord, except at places permitted do so by the competent authority,
Okay.
provided that no such
Let us read once again.
Yes, ma'am.
Let us read together again. You read it.
Yes, yes. No person sell
directly or indirectly sell or offer or expose for sale or buy beef or beef products in any form, my lord. And these are my lord package.
In any form, read,
in
very
any form.
important
form.
implications are there here.
Except at places.
So the sale is subject to what you say.
Yes.
Here the condition is directly or indirectly he will not sell.
Yes.
Okay. Or exposed for sale. It is not that exposed for sunlight.
Yes.
It is exposed for sale or buy beef or beef products in any form.
Any form.
So what is that? No person shall directly or indirectly sell or expose for sale or buy beef or beef products in any form.
Any form.
Okay. Except at a places permitted to do so by the competent authority.
Yes.
So this sale is essentially related to a place. Here your case, it's a transportation, not a sale.
Yes. My lord, here the
You show us that transportation sale permitted to do so by competent authority.
yes.
So there are two aspects of the matter. Why I'm expressing is that you should address those issues. These are not, we are not taking any view.
Yes.
But these are reading the proposition of law or enactment at 8. It comes to our mind that it relates to sale at a place.
Yes.
And place you can do a sale or expose it to sale only with the permission to do so by the competent authority under this act.
And thereafter, my lord, provided, no, provided that no such permission shall be granted in such areas or areas which are predominantly
So this is so therefore again relatable to a place.
Place, my lord. Yes.
Because it is area.
Yes, my lord.
It is not transportation.
Yes. And my lord, presently the petitioner is running a cold storage, wherein not only my lord,
cold storage will come later on.
later on, yes.
Cold storage will come on later on.
Later
What
on.
is your first point of offense?
Yes.
That a truck was carrying packaged meat.
Meat.
Not beef. Packaged meat.
Packaged
With all disclosure.
Yes,
that
sir.
this is manufactured, this is this. This is declared to be a buffalo meat. They are transporting buffalo, according to them, buffalo meat. According to you, this is not buffalo meat. This is a meat, beef.
Beef.
But this is not your case that at that point it was a sale. It was a transportation in a package condition. So therefore, our question is, when it is a packaged product meant for human consumption, and according to you, this is a misbranding. They are saying it to be, we are not
They
saying
are saying that,
misbranding. They
yes.
are saying, we are saying
Yes.
that according to, they declare to be buffalo meat, and whereas they are selling it, actually it is beef.
Beef.
So therefore, in such a circumstances, when it is an admitted, we know our limitation under 482.
Yes.
But these are admitted proposition materials on record that it was transported from Patna with this declaration, manufacturing date, who manufactured, everything.
Yes.
With in a vehicle which is having the refrigerating facilities, and therefore, according to them, it is a case under Food and Safety Standards Act, and it no way on the face of it come under Section 8 of this act.
Yes.
So therefore, you will have to satisfy the relation between the places and areas, the relevance of places and areas and sale.
And regarding, I would like, your lordship may kindly come to paragraph 6 of their petition. Your lordship has rightly before pointed out that packaged food, wherein everything should have to be mentioned, my lord, in the packet. So your lordship may kindly come to paragraph 6 of their petition, my lord, in their petition. Page 7, my lord.
Page 7.
Page 7. 8th line, my lord.
Just a minute. Paragraph 6, page 7, 8 line, yes.
8th line. License under 2006 and thereafter, my lord.
UP, Bihar, they are selling their products not only in India but abroad also.
Yes, the meat is hygienically packed and are having all specification
As per rules.
and all details are pinned in over the package material. Then your lordship may kindly come to page 33.
Page 33.
That is the my lord photograph of the my lord material, my lord. What are they are printed in the packet, my lord. Only because those my lord meats are in a packet, that cannot be said that those are my lord packed food. In fact, those my lord materials are not even my lord human. It can be said that there is
So
nothing.
you admitted these are the photographs.
There is nothing in the packet that these are my lord.
No, they say this is fresh frozen buffalo halal meat.
And nothing, my lord.
Okay. So if it is packaged fresh frozen buffalo halal meat,
yes,
where is your jurisdiction to seize it? That is the question.
My lord,
and admittedly this was seized at the time of transportation. While it was being transported and is in a checkpoint, it was found that these are packet meats. We doubt it to be, though they have declared, this is a statement on record. Though they have doubted it to be, though they have declared it to be frozen buffalo halal meat, it is actually beef. Therefore, we have started testing. Where is your jurisdiction?
This can gather information from various sources.
No problem on that. Police
here-
can send it to the forensic, no problem on that.
And because
But to assume jurisdiction, there must some foundational fact.
yes,
What is that foundational fact and under which authority of this Act 2011 Act was that?
because my lord, Section 8 specifically prohibited my lord any kind of beef and beef product.
That is what I'm saying. This is not a
And
case
now,
of sale.
my lord, on the basis of my lord source information, my lord, SP has initially, my lord, get an information that in the name of buffalo meat, my lord, somebody is transporting. Thereafter, my lord, that my lord, source information was my lord transmitted to the my lord other my lord officers, my lord. Thereafter, my lord, on the basis of the Naka checking, those my lord meats were my lord. The police, my lord, thereafter, my lord, checked those vehicles frozen by, and thereafter from that vehicle, my lord, while my lord driver of the vehicle was apprehended, my lord, he was asked where from those my lord food articles came from. Then he failed to give any satisfactory reply. Initially, he stated that those materials come from my lord Bihar. And thereafter, my lord, in the documents, my lord, it is found that those documents are from UP. Thereafter, on being, my lord, thereafter, police on being suspecting that there is no satisfactory reply from the driver, my lord, thereafter, my lord, police immediately, my lord, that officer, my lord, IO informed the SP of the concerned, my lord, district, and thereafter, my lord, SP immediately, my lord, intimated one of the veterinary, my lord, the doctor, and thereafter, my lord, he immediately rose to the place, and thereafter, my lord, veterinary, in presence of the veterinary doctor, my lord, some samples were taken from that, because source information is already there with the police. Thereafter, my lord, after taking those samples, immediately sent it to the, my lord, FSL, and thereafter, only after getting the report of the FSL that these, my lord,
We are well aware of these facts. Facts
Yes,
are
ma'am.
thorough in our mind.
Yes, my lord.
But to proceed with these facts, the whole question is, their argument is that they are having no jurisdiction. You have no, because prima facie on the face of it, no cognizable offense under section 8 of the Act is made out.
Yes.
This is their case.
Well,
Your case, let me
Yes.
conclude. Your case is that no, in terms of section 8, police
Yes.
has power
Yes.
because this will amount to a sale,
Yes.
and therefore it is purported for, it is destined for sale.
Yes.
So it is destined for sale, therefore a section, and because see, Mr. Bothakur, you'll have to have a legal argument.
Legal argument. Yes,
You
ma'am.
cannot say that we have got this information, we have done this, that will not do. Your argument should be under section 8, what is a sale?
And my-
According to you, when it destined for sale, then also it is a sale. That can be an argument.
Yes, well, in their
But you
petition-
cannot say that no,
in their
anything we
Yes,
can,
yes.
because it is doubted to be beef, we can seize it. That I do not think that. You can argue very well that no, sale will cover, in the scheme of the Act, sale will cover any material or beef which is destined to be transported for even for sale. When it is transported for sale, then also it will amount to a sale, and on for transportation period also there will be a permission for this. Okay,
Yes.
so that will be your argument.
And my lord, in this case, my lord, you'll see from their petition itself, it reflects that why those, my lord, meats were transported to Eden cold storage. Not only for storage, my lord, for retail sale also, my lord. In their petition, my lord, they have specifically stated that after getting those, my lord, food materials.
From where have you seized it?
Initially, my lord, yeah, from the, my lord, cold storage, my lord, later on, my lord,
No,
after
no,
getting
cold
the
storage, you have yourself has taken it to the cold storage.
yes.
And you kept it in the cold storage.
Yes.
And you have also seized the cold storage. That is
Yes.
one part of the story.
Yes.
First part, when affair was lost, what was the issue? That is what I am asking.
Initially, my lord, police has never seized all those, my lord, meats, my lord, at the place of the, my lord, where, my lord, those materials, my lord, meats were collected, my lord. Later on, police allowed the driver of the vehicle.
Let us see the scheme of the act
Yes, ma'am.
regarding beef. Forget about other cattle. What are the provisions as regard beef? Because your case is under Section 8, not under slaughter or something. Because admittedly, according to you, slaughter was done in UP.
Yes, ma'am. And they also, my lord, failed to show any of the documents that.
No, no, we'll come to them later on.
Yes,
We have heard their argument. Oh,
Yes.
they will have to satisfy.
Yes.
No doubt about that. They will have to satisfy that this is a case under 482 for Quasment.
Yes.
And we know our limitations and parameters. We'll go because to have that satisfaction, these are the queries coming to our mind.
Yes.
That's why you're asking. We'll go to their weakness. First, let us understand. See, Section 7 specifically says prohibition on transport of cattle.
Yes, ma'am. Yes, only on that is, my lord, live cattle.
Live cattle.
Live cattle.
And cattle has been defined.
Yes.
Cattle has been defined. Beef has been defined.
Beef has
Beef means flesh of cattle in any form
In
whose
any form.
slaughter is prohibited under this act.
Yes, ma'am.
Okay.
Yes.
So beef is defined, cattle is defined. Transportation is cattle is prohibited except in certain conditions. So far relating to bordering state, there are further restrictions.
Yes.
Only certain exceptions so far relating to taking it to the registered cattle market and to the grazing ground or to the field.
Yes.
Otherwise, you cannot even transport cattle.
Transport cattle.
There cannot be any good
Any
reason
good reason.
except this.
Yes.
So, but let us see what are the provisions of beef except Section 8.
Section 6 is, my lord, prohibition of slaughter of cattle. in cattle.
Section 6 prohibition.
Yes.
No, this your case is not slaughter. Your
Otherwise,
case is
Section
slaughter
4
is either in UP or in Bihar. We are not
Yes.
concerned, not within the state.
Yes.
That
Not-
is your
not
admitted
within the
question.
state, my lord, but that part also needed to be investigated because, my lord, there, as per information, they stated that those meats were collected from those places of the, my lord, UP or Bihar. So till now, investigation is going on those places also.
No, no,
have to
these are arguments for the
investigated by the
purpose of it.
police.
We are on a different footing.
Yes, yes.
Let us see first understand the prohibition of beef. What are the prohibitions? Section 8 or any other prohibitions are there? Where is the prohibition to permission? Prohibition? Permission of selling beef. Which is the
Yeah.
prohibition?
Yes, my lord, rules, my lord, rules provides,
Rules provides.
yes, my lord.
What are the provisions for?
Some,
See, here also, if you read the rule, it is SOP. That's why I'm asking area, sale, and now it is SOP. So you'll have to read a rule in the context of the principal section as
Yes.
well as the scheme of the act.
yes, my lord.
This is so section 8 is clarified by this rule. So beef can be sold only in a shop license in terms of section 18
Yes, my lord.
with a permission under rule 9.
Yes,
Only a shop.
yes, my lord. Only a shop.
So therefore that is why I was asking that what is the relation between area and place of sale, that is then emphasized in section 8.
Yes.
Now rule 8, rule 9 clarifies that it is a shop. Otherwise, so whole reading will be the except shop you cannot
Yes.
sell it.
Yes, my lord.
Anything? What about?
Otherwise, well, from the contents of the FIR and from reading the provisions, as your lordship has rightly pointed out, and provided that, my lord, regarding the last portion of the section 8, my lord, provided no such permission shall be already, my lord, this is having a the petitioner is having a license. That license is annexed, my lord. That is for cold storage, and my lord, now petitioner is, my lord, in the name of, it is from the FSL report and everything during the investigation has been collected by the investigating authority, my lord, it is very clear that those, my lord, meats are, my lord, beef. From 2 FSL report is available from 1/8/12/23, and thereafter, my lord, later on sample collected from the cold storage also.
What about, can you give this in a small note
Yes,
that
my lord.
when it was seized, when it was
Yes,
sent
I have
for
also the
ethic,
one-
when veterinary doctor was
Yes,
given?
one inquiry report is also there of the, my lord, police.
Just give those dates.
Yes, my lord.
Give those
And-
dates.
And thereafter, my lord, suppose, my lord, police has committed a wrong during investigation, that, my lord, initially police should have been, police, after.
No, we are
getting
not
that
on, see,
Yes.
suppose we cannot comment under 482 what procedure police should adopt
Yes, my lord.
for having an expert opinion.
Yes,
What is
sir.
forensic? Forensic is an expert opinion.
Opinion.
So whether they obtain an expert opinion from an economist
Yes.
on a science topic, or they obtain information on something else or from a non-expert, that
Yes.
will be a subject matter of cross-examination during the trial.
Yes. sir.
We are not on that. Initially, that was our thought, how can this, because that will under 482 will not go to that extent.
Yes. sir.
It is up to the investigating authority where to obtain an opinion. Because the CRPC provides that they can seek an opinion. And forensic is an admittedly, and it's a, you can take it's an expert authority on certain points. Whether they can give opinion or beef and buffalo or not, that can be a subject matter of cross-examination.
Yes.
That is not our, we are not on that
Mm.
for the time now. But on section 8, rule 9, and your admitted facts that these are brought as buffalo meat for intended sale. This is your case.
Yes.
And therefore, in exercise of power under section 8, your offense is registered under section 8.
Yes.
Isn't it? So therefore, according to you, this is a prohibited thing and they have says selling it with on the basis without any permission. This is your case.
Yes. And your lordship may kindly one another aspect, your lordship may, I would just like to point out for your lordship, a criminal, one of the reply filed by the petitioner, my lord, additional affidavit. One letter addressed to the my lord, DGP, my lord. 412, I would just like to point out, my lord.
Space.
This is additional affidavit filed by the petitioner, my lord. Page number 65.
Page 65. Yes.
Detention regarding, my lord, to the Director General of Police, Assam Police Headquarters. Dear sir, we are one of the oldest cold storage company in Northeastern region. Our cold storage was established in the year so and so, and from then on, we are giving service of cold storage to farmers, traders, wholesale distributors in Northeastern region. Our vehicle was detained in Srirampur border outpost on 29th November 2023. It was released subsequently late night with 2 constables. The vehicle was carrying stock ordered by distributors in Mizoram. The vehicle was carrying stock ordered by distributors in Mizoram. The stock was unloaded in the cold storage and specific instructions were given not to send the stock to Mizoram till laboratory report is received by the police of Beltola police station. As a company, we want to be in the right side of the law and we want to follow all prevailing laws of the country to the last details. We are aware that Government of Assam has enacted the Cattle Preservation Act 2021, which prohibits the transportation of cattle inter-district without the approval of competent authority. Section 8 further prohibits sale of beef in areas predominantly inhabited by Hindus, Jain, Sikh, near temples, satras, etc., and also exposed beef sale in those areas. That the sale of beef under this section is not prohibited in Muslim dominated areas, so that the sale of beef under this section is not prohibited in Muslim dominated areas, nor it prohibits transportation to our neighborhood states like Nagaland, Meghalaya, Mizoram, Manipur, etc., where they consume both beef and buffalo. That our driver of that vehicle.
So what do you want to say? This you want to say that they have admitted it to be beef.
Admitted this is beef, my lord.
That is your argument. No, this happens when
my
you
lord,
are
they
over
stated
excited.
that those meats are for transportation
Yes.
to other states. Now, there is no such documents. They fail to produce any documents that those meats are specifically meant for those states, my lord. Also not produce any document that in that particular place of the state, those meats are for transporting, my lord. My prayer before your lordship that this in this case
Your argument is that this is not a fit case for 482.
yes,
It's a factual
investigation.
determination is required. So therefore, this is not a case for 482.
Yes.
Yes.
My lord, the case which we have projected, my lord, in our case, if we go by the FIR, my lord, they have registered the case.
Are you confident? What is your case projected?
Yes, yes, my lord.
Confident?
The case which we have projected, my lord, is that this cattle preservation, the Assam Cattle Preservation Act 2021 is not applicable.
Where
in
is
our
so
state.
that?
My lord.
Show us from your pleading.
My lord, pleading I have done from, my lord.
Huh?
Pleading in the petition, my lord.
Yes.
Yes, yes, my lord. We have quoted.
Why not applicable?
My lord.
Why cattle preservation is not applicable according to as per pleading?
My lord, the pleading we have stated in, my lord, at page 13, my lord, paragraph 13, my lord, that the may I read, my lord.
Yes.
That the petitioner begs to state that as per section 11 subsection 1 of the Assam Cattle Preservation Act 2021, a police officer not below the rank of sub-inspector or a registered veterinary officer or any other person authorized in this behalf by the state government shall have the power to enter and inspect any premises within the local limits of jurisdiction of such person where he has reason to believe that an offense under this act has been or is likely to be committed. Now, my lord, the case which the prosecution is, my lord, in the FIR is that, my lord, while this, my lord, material, alleged beef, as per their allegation, my lord, while it was being transported, my lord, they have apprehended in a NACA checking, and my lord, they have suspected that the beef, that the meat which we are transporting cannot be a buffalo meat.
No, tell
So-
us, can violation of 11(1) be ground for quashing of the proceeding?
Because, my lord, if this act
No,
is,
tell us that first.
yes, my lord.
Because reason will come to later on.
My lord, absolutely why I am submitting with all respect, my lord. Because, my lord, if the provision of this section is not applicable, the
No,
registration.
section 11(1) relatable only to search and
Search and
seizure.
seizure. First of all, my lord, if you go by the provision of section 8 also, my lord. As my
No,
lord.
section will come later on. You are on section 11.
No, my lord.
That's why I have asked, what is your case?
My lord.
Where is the question of section 11 in your case?
No, my lord, section 11, they have, later on, they have searched
no.
and seized, my lord.
Whether section 11 will vitiate the entire quashing is for
is-
defect in search and seizure.
My
Is it a proposition of law that you are arguing that for the defect in search and seizure, whole prosecution will fail
No,
and
my lord.
FIR is liable to be quashed?
No, my lord, my respectful submission in this regard would be, my lord, as the section 8 and section 11 is correlated, my lord. If section 8 is not applicable, my lord, then section
No, no,
11.
section 8 is not applicable is a. So let us, so where have you said that this is not section 8 is not applicable?
My lord, actually, we have projected the case that under our, my lord, offense.
That is
with-
why my first
My-
question was, what is your case and what is your
My
pleading?
case is that we fall under the Food and Safety Security Act, my lord. So if any, my lord, offense is committed for the similar offenses, my lord, there are provisions for punishment under.
No, that is your case, we understand.
My lord.
But suppose there are two legislation
Yes, my lord.
which permits search, seizure, confiscation, arrest, registration of FIR.
My lord.
If section 8 is applicable
My
in your case,
My lord.
then why not?
Because, my lord,
When there are parallel proceedings
because
can be done,
my lord.
they can very well
No, my lord,
register.
with my very limited knowledge, my lord, what I am respectfully back to submit, my lord, when there is a central law governing the field, then, my lord, this.
No, no, it's not governing the field. Central law is governing the field so far relating to food and food safety and standards. Food safety and standards.
Exactly.
Suppose food safety and standard will come later on. If section 8 covers you, then food safety will take a different, this can parallelly go. Because these are two separate and distinct offenses. One is so far relating to food and food safety. If you can go to the object and what is food safety, that is clear. That it should be in a packaged food, there should not be any adulteration or there should not be any declaration which will misbranding. These are their offenses are defined.
My lord.
Under food safety, offenses are defined. There are 3 or 4 offenses.
Misbranding is also there.
Well, misbranding is also there. Misbranding is also there.
Now they are saying,
Suppose it is their case that you are selling beef.
My lord.
That will be an offense under the act without permission. Suppose their allegation is that you are selling a beef in a shop without permission.
That is not their case, my lord.
No, that is not your case also.
Our case, my lord, is
That is why I'm asking. That is not your case also.
My lord, my case is that we have been detained, the, my lord, the material.
That is not your case. You
Material.
are not nowhere you are saying. That is the thought of this court.
My lord.
This is nowhere. No, there is no mention of section 18 in your petition. Section 8 in your petition.
The pleading, my lord.
Pleading. Can you show me
No, my lord, it is
that
not
section 8 is not applicable in this case? Your whole case is that this is a food and safety.
Because, my lord, we projected before my lord, that as the Assam Cattle Preservation Act is not applicable for the offense which they have defined. we come under the Food and Safety Security Act. my lord. So once the Food and Safety Security Act authority and jurisdiction is completely
Section
different.
11, we are not so impressed.
My lord. Now, my lord, this section, they have registered the case under section 13, subsection 1, my lord. For the offences committed, if my lord go by the provision of section 13, my lord. My lord, it is the provision of penalties, my lord. My lord, whoever contravenes any of the provision contained in this act under section 4, 5, 6, 7, and 8 shall be guilty of an offence punishable with imprisonment for a term which shall not be less than 3 years and which may extend to 8 years and with fine. So this is the, under this provision, my lord, they have registered. Now, my lord, as the, my lord, it is the operation of law, my lord, perhaps, my lord, although it is not a part of the pleading, but the, my lord.
We
my lord,
understand.
I
We understand,
I
but
respectfully
your
agree, my lord.
whole case is
lord.
projected altogether fully harping on only on food and safety. Food and safety, we understand. Why should all this necessary?
Because, my lord, the
Food and safety will come. First question is that this offense will not fall under section 8. What is the our power for Quasman?
if, my lord, if the FIR which is registered on a wrong footing, my lord.
When the FIR is registered and on player reading and taking everything to be correct, if no case under section 8 is made out, it is gone. This is not your case.
But, my lord, it is the by operation of law, my lord, automatically it will go. It is the statutory prescription, my lord. Now, my lord, if we go by the FIR, my lord, the allegation which they have, the case which they have registered and in the FIR which they have alleged, it is
Mr.
my lord.
See, question is not that. Just remind yourself, we remind ourselves, we are exercising a power under 482.
When abuse of the, when there is an abuse, my lord.
For a 482 to come to an abuse, we'll have a satisfaction first that this is a not case under 482.
Fine.
We are not so much interested in what is the procedure under food safety under 482. We cannot make factual determination that this was manufactured in such a, it was this and that. Therefore, it is a food. And this, therefore, this is not that. We cannot go to details in a 482 petition. Factual assertion is whatever available material available on record, if it is taken to be correct.
Then, my lord, may
This is number one.
My lord.
Number two is that even if we can rely on uncontroverted and admitted document, it's not that 482 we are not powerless. Even we can take note of the admitted and uncontroverted. Suppose this they have made a seizure of a document, they admit that this is the material. If that discloses something, we can admit, we can accept it under 482. But beyond that, controversy is there, denial is there. In 482, we cannot go to that.
My lord, a plain reading of the FIR and a plain reading of the section 8, my lord, it automatically transfers, my lord, that the case which has been registered.
Let us see where have you stated that.
My lord, the statement part, I am, my lord, is very, my lord, may I pray, my lord, that I may be allowed to file an additional affidavit, my lord, to cope up with my lord, this lacuna in the pleadings, my lord.
I have tried to go through from page 1 to last page.
I can
That no case is made out. This is an abuse of the process of
Abuse
this
of the
case.
process
Nothing
of
is there.
my lord.
And that these are the materials on the basis of which it is accepted. These are documents that
Fine,
that is. Mr. Bothakur, case diary is there, na?
Yes, ma'am.
Case diary
Yes,
is.
ma'am.
You give a note.
Yes, ma'am. Yes, there is one inquiry report of the IO is also available, ma'am, in detail.
No, no, no.
You will have to
Definitely pleading for-
give a handle to the court.
My lord, I will file an additional affidavit.
Heard, Mr. On the last occasion, hearing on behalf of the petitioner was concluded. Mr. Bothakur has argued the matter today. Full stop. Mr. Bobia, learned counsel for the petitioner.
Bhoya, my lord.
Bhuya, learned counsel for the petitioner submits that he may be granted some time to respond to the argument of Mr. Borthakur. Prayer is allowed. This will help me, na?
Yes, madam.
That,
Inquiry report
that,
detail,
that
my lord.
facts when,
Yes,
what
yes,
is.
yes, madam.
Mr. Borthakur has produced the case diary as well as a report, inquiry report submitted by
The IO.
IU of the case before the Superintendent of Police Kokrajar.
Yes,
Which the records are kept with the file.
yes,
Records are kept in the chamber
yes.
for consideration and perusal. List this matter on
19th, my lord.
19th.
My lord, may I pray, my lord, that the forensic examination which has been done, can I get a copy of that?
What is the, suppose there is no case is made out. Do you suggest that we should go by the forensic?
Because, my lord,
No, we'll not listen. Do you want that for forensic report? Then it is a thing, then we may take a view that this can now parallelly proceed. They will report to the food and safety that this has been done.
Right.
Many questions are there.
I know.
Be prepared.
Try to satisfy, my lord. Those lacuna, I will, by filing an additional affidavit, my lord, will make up.
Mr. Borthakur, those just you also have those provisions.
Yes,
I
sir.
think
Section 32,
section
31 is
32 or something 37.
my lord. 37, 38 and 41, my lord.
37, 38. 30 is not so necessary.
38 and 41.
Thirty-eight is important. Now 42 is important.
Koro kita.
46 is important and chapter 9 is very important.
Yes.
Section 48.
59, my lord, overriding effect is also there, my lord.
Now section 52 is important in this case.
Section 89 says, my lord, overriding effect on all other laws regarding.
We'll come to that later.
My lord.
52.
My lord.
Overriding, Mr. Bhuya, overriding effect when same subject is occupied by two legislation. Overriding effect will come when the same situation is, suppose this also is regarding food safety and adulteration. Then there will be quick question of notwithstanding anything or here the situation is absolutely projected different.
Criminalizing and
Criminalization and the adulteration. One is sale of beef is banned, and according to them, you have sold beef in violation of Section 8. Where is the provision of food and safety will debar their action?
misbranding is there, my lord. If we misbrand.
Therefore, that is what I am asking. Prima facie, it is to be satisfied on the material that this is not a case of sale, this is a case of misbranding.
My lord.
And you have nothing on that.
My lord, this
You are saying what not? Whole of the Food Safety Act is in your pleading. But what fundamental thing is required is not there. That is the result of excitement.
And
So why not? We cannot say that they cannot proceed. They will proceed. Suppose you are selling this packet in a shop.
Without license.
Without license, then
that is an offense.
And even, my lord, I may be wrong, my lord.
But even this is not a case of misbranding also, my lord. Why I am saying so, my lord? Suppose they
No,
are
let us
saying,
hear them on
Yes,
misbranding,
yes.
then you respond to it.
yes, if they can plead now about misbranding, my lord, then also I will point out your lordship, this is not even.
So you keep your,
By taking the advantage of misbranding, you are committed an offense, my lord. What is there in the?
and
petition?
also you'll have to address the power of this court under section 480. To what extent it can.
Regarding Zimmer petition, my lord, no order is passed.
When online goes in.
217. Revision
No, no, we have already signed this order. Already signed it. We'll verify it. We have already signed it. Something. No, we have separated it. We signed it. I upload it. Huh? This. We'll verify it. That is separated on that day only.
Well, on 19/7.
19/7. Yes, how many times we will hear this matter?
Thankfully, this issue was actually pending before the Supreme Court.
That is why we are
And
settled.
thankfully that has been settled, and I placed one judgment of the DGOF Employees Association. And if your lordship may kindly note down the paragraphs of that
give us.
particular judgment. Okay, fine,
Sometimes certain things it takes the backseat.
But sometimes it is for the better.
Better. Where is that order?
It's a Manupatra judgment. Your lordship.
Where is that? Have you furnished?
Yes, last occasion it was punished.
PJ Mohan Panikar.
There was a bunch of judgments.
Okay. This is
Union of India versus DGOF Employees Association.
which year?
Decided on 9/11/23.
No, I'm not having it. 3-4 judgments are there, but those which you have. Just give it.
There the paragraph numbers are mentioned at the top, your lordship.
Now, what kind of order you should pass today?
In fact, my friend is relying upon a judgment was just given. I would just like to differ from him. This is the case, if your lordship, there are two tables here. Here, the scale was the same before. Later on, it was changed. Therefore,
So if he says that this is covered by this judgment, suppose assuming for a moment. Now, should we go to the details of this case, or we can say that petitioner submits that his case is covered by this judgment and issues are settled, therefore he will approach this authority in terms of this judgment. And
they have reservation since.
no, this is his. We are not determining that you do on the basis of this. At least we can record his submission, and you will have to ultimately you will have to say that whether factual aspects, whether these both are covered, they will have to decide.
We have to agree. But since my learned friend is contesting that this judgment will not apply, but for my as a submission, which will actually which actually support my submissions, your lordship. This judgment supports my submission. Your lordship may take it in that sense because I have submitted other.
No, therefore, what shifts two options with us? We'll take this judgment, go to the facts. If it is covered, we'll pass a concrete judgment that this is applicable. So therefore, the petition is allowed. This is one aspect. If you dispute, then we need to go through a phrase. And if according to him, he says that his matter is pending so long, and today may not be possible to dictate the judgment. So what I was thinking, if that is the situation, according to him, we'll quote his paragraph and say that his case is covered by this judgment in the given facts of his case. So in that view, he'll go and file a representation. You decide this. That can be.
Would again prolong the whole issue.
Okay.
Because I have actually annexed that.
Okay, you show us this paragraph. Which are the paragraph?
Lordship,
Your Lordship, the original judgment is a division bench judgment of the Honorable Delhi High Court, which I have annexed in my rejoinder. That particular writ petition was allowed. And the department, the Union of India, filed a SLP for the Supreme Court. That SLP was dismissed in this particular judgment which I had just placed, Your Lordship. So, if Your Lordship peruses through the judgment which I have annexed in the rejoinder of the writ petition, and this particular judgment passed by the Honorable Supreme Court, everything will be clear, Your Lordship, because the whole issue as such is that I am claiming historical parity vis-a-vis the pay scale that was given to those in the those assistants and secretaries in the secretariat organization in Delhi. Now, that disparity was actually happened in the year 2006, just before the constitution of the 6 CPC. I have submitted my written arguments also in this matter.
Yes, I've got it.
And therein, I have highlighted that just 10 days prior to the constitution of the 6 CPC, what the respondent number 2 did is they upgraded the pay scale of the only those assistants and secretaries in the secretariat organization, secretariat office, but not in the field organization. This disparity was actually frowned upon by the 6 CPC. Now, I agree, I totally agree to the learned submission made by my learned senior in this case, that yes, pay fixation, pay parity matters are totally left to expert bodies. Court normally does not look into this kind of matter, but only and only if there is some kind of arbitrariness. And this was actually observed to be arbitrary by the Honorable Supreme Court in this latest decision, which is purely identical to my case, because in that case also, the Ordnance Factory Board employees who are field organization employees, they claim parity in pay with regards to the parity in pay given to assistants and secretaries and private stenographers in the secretariat office. And therein, the Honorable Supreme Court said that this particular upgradation, this particular word was basically a diversion, which actually went, which actually further encouraged the gap, which the disparity between the field and the secretariat organization. This was actually frowned upon, and Honorable Supreme Court said that no, the 6 CPC is the expert body. 6 CPC is the expert body, they will take the decision. And they took the decision. And they actually recommended that there should be parity in pay between field organization and secretariat organization. And based on that particular notion only, the Honorable Supreme Court said that no, you cannot have two different pay scales, because we are there just to see that arbitrariness part, and there has been arbitrariness on based on this particular annexure 2, which I have annexed in this writ petition, this upgradation, which I challenge also. That particular thing was turned down. And Lordship, this rejoinder, in this rejoinder, the Delhi High Court judgment is more second and basically elaborative. And the Honorable Supreme Court only went into certain portions of those that particular judgment. Now, if your Lordship goes,
What is the Delhi High Court judgment?
it's in my rejoinder, annexure R1,
Page
page 11 only.
rejoinder by the petitioner.
By the petition. So against this judgment only, they went to Supreme Court. And if I take your Lordship to the relevant paragraph, page number, your Lordship, page number 22.
Page
22.
Paragraph, tell us paragraph, because here,
Paragraph 15.
paragraph to
Then paragraph number 18, page 27.
page, paragraph 22, paragraph 15.
Paragraph 15. Then your Lordship may go to paragraph number 18, page 27.
Paragraph 15. Paragraph 15.
Then paragraph 18, page 27. Then paragraph 19.
Yes. Paragraph 19.
Yes, paragraph 19, the whole paragraph. It goes
What is
on.
the final conclusion?
Ultimately, your lordship, final conclusion is at page number 38, paragraph number 26.
20.
6, paragraph number 38, page 38, paragraph number 26.
Page 38, 26.
That from the word consequently, from the bottom, it's line number 1. 8th line from the bottom. Consequently, a direction is issued to the respondents to fix the member of the petitioner association at the similarly placed assistants working in ordnance factories and in OV in the same pay scale as was given to assistants similarly placed in CSS, Army Headquarters, UPSC, etc. with effect from the same date as was first given to them. Consequential pay fixation and fitment orders shall be issued within 8 weeks from today. The petition is allowed in terms of the above order without any.
Now, thereafter this judgment.
Thereafter,
23, 9/11/2023.
9/11/23.
Which paragraph in this judgment?
Your lordship, I just had given my copy. Your lordship, in that judgment copy itself, I had marked in red color pen. The
18.
page numbers, the paragraph numbers, your lordship.
Okay, keep a Xerox copy of this. Not possible today.
Yes.
Was agreed to by the learned counsel for the petitioners. List this matter for further hearing on. Give a date.
Can it be on July 18th, your lordship?
July 18th.
18th.
18th. 18th of July. Subject to the condition that I am sitting singly.
Your lordship.
18th, 19th.
It is Xerox করে রাখিব.
Sunday.
Keep a Xerox copy and give it to her.
Lordship, if it can be,
Give a convenient date for both of you.
Lordship, 18th, I will not be there. 23 again, I will be out of town. If it can be on 19th, Lordship.
19th.
19th
That is a Friday, Lordship.
motion day.
Okay. Hey.
No, এই সপ্তাহ তোমার মোটামুটি না থাকবে। কিন্তু আজকে কিভাবে ফিক্স করে পাইনি। হ্যাঁ? 16th of February.
16th, your lordship.
If your lordship, if it is not inconvenient on 16th.
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 Mostly 16th. We'll finish up that day.
Yes, yes.
Okay. You have also submitted your written argument, isn't
Yes,
it?
yes.
So otherwise I thought that we'll make it heavy, but in your presence, if we start the dictation, defects will not be there as regards facts.
Otherwise, in the meantime, your lordship may kindly peruse through these 2 judgments.
We'll see these 2 judgments.
In the facts.
That's why I have asked her.
In the facts, Lordship, whether this judgment is.
You also go through it, Mr.
No, I have taken a copy.
I've given a copy.
You go through it.
Yes, yes.
You go through it, have an opinion from your clients also in the meantime. That copy, you keep it with her. A2 CD2.
One again.
Pleasure, your lordship.
Yes. A2. Yes, Goswami.
Lordship.
Concluded. You want to add something?
I have not started.
Okay, you start. You will adjourn your case.
Yes. Only one point, my lord, to be noted, my lord, in the facts of the case, my lord. I have already undergone the sentence.
We have already undergone. So
Yes,
that was, so
that's the point, my lord. So lordship may fix as soon as possible, my lord, for the bill, at least.
if you have undergone, then you ought to have been released.
That's why, my lord, the substance is psychotropic substance, 48 numbers of tablet. It comes, my lord, below, my lord. And from the inventory also, my lord, it comes around 2.62 grams, 48 tablets.
Should we release it from part?
No, my lord, let it be, because we have also, lordship has also gone through it.
No, gone through it, but
Immediately after the.
yes, what about you?
All matter is 45, 46.
Your method is he's raised a objection as to the maintainability.
Yes, sir.
We'll now address today the maintainability, if time permits. Or if it, or what to do otherwise, if time is not there, then we'll release it from part hard.
No, that we will not like to. Lordship may keep it.
No, problem is that this is what is happening.
No problems, Lordship. We can take one more date thereafter if Lordship feels, then it can be.
Okay, let us, yes, Mr. Goswami, I want to finish it of this matter.
Yes,
Otherwise it will go, after vacation, everything will go.
because it will, I will also take the losses some valuable time, my lord.
Mr. Doctor,
On 16th.
see, after vacation, we are not clear
My lord.
what will be the situation.
Because Lordship has also gone through it, my lord.
No, I have
thoroughly.
gone through it.
I have also, my lord.
But problem is this nowadays taking, see, criminal, we are in the midst of 6 pay commission.
Yes, my lord.
Now coming to NDPS. Before that, what not now, that maternity date.
Let it be parted, my lord. No fixed date, my lord. Can it be said, my lord, in the 3rd week of so and so?
No, that part hard method cannot be like
Yes, that's true also. So we'll take a chance on 16th, my lord. 16th of July.
that. How many? Just how many metal?
Nine hours. 17, 18. That
Nowadays problem is that bails are following.
Yes.
If
my
you
lord.
reject, or if you reject one accused also, other accused also come to your bench.
Direction from the Supreme Court.
There is also a problem, my lord. That has to be addressed, my lord. And that submission I'm not making in this court, my lord. That is a serious problem, my lord. 4 accused, my lord. 1 judge has given, another rejected. Where to go, my lord?
This happened in my cases also. In one case, I have, it was not to my
Yes,
notice
ma'am.
because that was prior to the judgment.
Yes.
Somebody rejected, one accused, I have granted. Now to which bench will it go?
That's the point. On 18, my lord, you will try and take a chance.
See, these matters are long pending in this bench.
lord.
So
My
I
matter-
want to finish it off.
Then any date, your lordship pleases, my lord.
24th.
24th, my lord.
24th, other matters also we have fixed.
I'll give a written argument, my lord. That will be better.
Keep a written argument. And what about you? Then
I'm
also
obliged.
we will also fix it.
Thursday.
We do not know because I mean, this is today's is a stopgap arrangement because that bench is that's why all these orders matters and all and my part hard matters.
In our case, my lord, all come. Apart from the maintainability, on merit also lordship can decide because it will be small issue, it will be involved after the
No,
maintainability. part.
that is not the issue. Issue is if you can satisfy that maintainability is overcome.
Yes, sir.
Or that even if it is case of maintainability, you can satisfy that matter is admitted.
Yes, lord.
There are some judgments and it is not a rule, it's a rule of discretion, not absolute, but if you can address that and if you can satisfy at the first hurdle, then of course we'll go to the merit. But if you cannot satisfy on the first point, then we'll not go.
So,
We know this is not an absolute bar, this is rule of discretion, but
yes, lord.
to what extent? When a code is itself complete, like SRFAC, maybe in income tax, There is appellate provision, revisional
My
provision.
entire argument will be on the basis of the jurisdiction, that there is no
Ah,
jurisdiction during that point of time.
If
I can
jurisdiction
succeed on
is an
that
issue,
jurisdiction.
those three exceptions,
Yes.
and recently some new tone has been given to this alternative remedy in some recent judgments.
Made it
I have
stricter.
some recent judgments of this honorable court, after the three cases has been disposed of after the order dated 21/3, where the detailed order has been passed with regard to such cases.
Which judgment?
Three judgments, recently WPC 3080/24. I'll show it to you.
In whom parties
By
name?
this court, my lord.
By this court?
No, by this, not by this
Okay.
court. Next.
We can take it. this way.
Recently, we have passed a judgment for better for him to consider.
I'll look for it.
I think day before yesterday, it relating to tax, GST.
GNRC,
GNRC.
that was not in favor of me, I guess.
Huh?
That
That's
was
against
drafted
you.
by me only.
That's why I have given you the handle so that you can reverse the mind. I'm open.
Drafted by me only.
Yes. Okay, give a date on in their matter also. Give not give the same date. All these are different. I'll finish it up before immediately after.
Not sure. 25th, then it-
Yes,
July.
25th.
Highly obliged.
Yes, what do you say?
Not in a matter.
I was thinking of finishing of this matter before vacation. And that Mr. Your matter is also all, in fact, we have dictated all the evidences
Yes, my lord, in this case.
Execution witnesses.
are already over.
Some defense witnesses.
Yes. No, that also you have done in the chamber.
Perhaps, my
All evidence are recorded.
that can be, before vacation, we can. my lord,
No, I don't have a allotted bench before
Lots.
vacation. It was unforeseen, therefore, otherwise I had a plan to before vacation to finish it off. And your judgment is also there. Hopefully on 28th. That CAV is. Yes, yes. There will be no CAV pending on 28th. Except fixing these 2 days. What to do?
From our side, we have submitted that bullet points also. It's on the
Yeah, I
record.
have seen.
So Bora sir has already concluded, but
Can you give a bullet points to him also?
definitely we can give.
So that you can respond. You will have to respond to
Yes,
just
madam. Yes,
his
4-5 points I have to respond and also.
4-point base. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Give a copy to him. We are not giving a date here. We'll see if it can be possible. And that also we'll have a talk with registry if possible. We'll conclude on Friday.
Friday, I have some difficulty. Friday.
Friday you have
Thursday-
difficulty.
Thursday and Wednesday, Thursday.
We'll take a chance.
Because
In your
that
so
case-
in Chaudhury's case, there is no urgency as such because all are outside on or on bail. In his case,
Old pending case.
all pending case. That is why.
yes, 2000.
But sometimes it's not humanly possible also.
Not.
These 2 matters I will think over and fix it. You are having
Except Friday, man.
except Friday, and you don't have any problem on. You have completed your argument. You will have to hear her also
Yes.
because she want enhancement.
And also, my lord, our state appeal is also there.
State appeal also. Okay, we'll think over these 2 matters after some time. Over? List over?
No, my.
Etu to
Yes.
delay? Etu to delay? These 2 matters. These 2 matters will decide later on. These 2 matters. Give a date in that case. That boy from outside. Key numbers later. That hotels.
46 to 48.
Hmm?
10-20.
No, hetu 25/7. তাহলে যেটুকু বেশি। These 2 matters I'll have a talk to registry and then we'll think. Yes.
15 will be assigned.